All right. Hi, good evening, everyone, and welcome to the Oxnard Community Services Public Safety and Housing Development Committee meeting for March 25, 2025. Madam Clerk, may we get a roll call and posting of the agenda, followed by the Pledge of Allegiance.
Chair MacArthur,
Here?
Committee Member Perallo,
Here.
Committee Member Pettis.
Here.
The agenda for this meeting was posted at the kiosk at City Hall, the Oxnard Public Library, the city administrative offices, and on the city's website on Tuesday, March 18th. Thank you.
Thank you. If I can have everyone stand, Councilwoman Perez is going to lead us on the Pledge of Allegiance. Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. The next item on the agenda is public comments for items not on the agenda. Madam Clerk, are there any speakers for items not on the agenda?
Chair MacArthur, we have two virtual speakers. Let me see which items they'd like to speak on. Janet, if you can press *6 to unmute, please let us know if you are speaking on items not on the agenda or which item. Janet?
Sorry, I was having a hard time unmuting.
Okay, which item would you like to speak on?
I would like to speak on the item regarding fines and fees.
Okay, so that'll be a little later. So right now, it's items are not on the agenda. So we'll keep your hand raised, and then we'll call you at the appropriate time.
Thank you.
Thank you. Sorry, the next caller will be Erica Holmes. If you can state which item you'd like to speak on. We're taking public comments on items not on the agenda at this time.
Hello?
Yes, Erica, right now we're taking public comments on items not on the agenda. Which item would you like to speak on?
Same as Janet, I'd actually like to concede my time to her.
Okay, thank you. We will, all right, if we can, we'll move on to the next speaker. This one would be Cami. Please, right now we're taking speakers on items not on the agenda. Could you state which item you'd like to speak on?
I think we're all in the agreement that we would would also like to speak on the item later on in the agenda.
Okay, which item? We have two items.
Same as Janet and Erica.
Okay, we will call you at the appropriate time. Thank you. Mayor, that actually concludes, we have no speakers virtually or in person for items not on the agenda. Thank you.
Wonderful, thank you. In this case, then we'll move on to the consent agenda. And the only item for consent is the approval of the minutes for the March 11th, 2025 Community Services Public Safety Housing Development Committee meeting. Do any members of the committee have any questions or comments?
If there's no public comments, I have no reason to have any changes. I don't know the rest of my board members. I'd move the recommended action if there's no recommended changes.
Thank you. There's no public comments on this item?
And Mayor, just for the record, we don't have any public comments virtually or in person for the information and consent agenda. Thank you.
I'll second the motion by Councilmember Perallo to approve the minutes.
Thank you. Committee Member Perallo?
Yes.
Committee Member Bettis?
Yes.
Chair MacArthur?
Yes,
And the motion carries 3-0. Thank you.
thank you. And also, we're going to, instead of moving on to the next item of the agenda, which is item D1, we're going to swap and take item D2 before D1 if there's no objection to that.
Just an explanation to the public watching why we're doing that. It's a very reasonable request.
Yes, the reason we're doing that is we have a number of speakers that are here this evening to speak on item D2, and so for consideration of their time, I know it's late in the evening, there's a lot of folks here that have to get up early and work, so for consideration of this item and for the public and for staff, we're going to move item D2 to D1. Thank you, Councilmember Perlow. So item D2 is from the Housing Department. The subject is the Tenant Anti-Harassment Ordinance. The recommendation is that the Community Services and Public Safety Housing Development Committee review and recommend that the City Council approve the first reading by the title only and waive further reading of the proposed ordinance titled, it's in quotes, Ordinance of the City of Oxnard, California, adding Article 3 to Chapter 27 of the Oxnard City Code establishing tenant anti-harassment protections, and review and authorize 2 full-time equivalent FTE positions and the associated budget as part of the fiscal year 2025-26 budget for implementation of the proposed ordinance. And Interim Housing Director Brenda Lopez is the contact for this. Before we get started, Ms. Lopez, are you able to give us just a brief overview of what this entails?
Good evening, Mayor, City Council. Albert Mayer is Assistant Director. This item before you today is, in response to some recent complaints that we've received from tenants with respect to harassment that some of them have been experiencing. What we've seen is, as you've all heard in some of these, in some of the council meetings, that there has been complaints around landlords taking various tactics to reduce housing services, to threaten that they would be calling immigration services, or refusing to complete some repairs required required by local law. Oftentimes, these complaints and these tactics end up forcing tenants to vacate their unit. And what that does is it ends up, which allows landlords to reset the rent, if you will. So a lot of times these tactics are in an effort to have tenants vacate their units and then allow them to reset the rents to potentially market or to whatever level that they'd like to see. This is common in a lot of rent control jurisdictions throughout the state of California. Several jurisdictions such as Santa Monica, West Hollywood, Oakland, San Jose, LA have adopted similar anti-harassment ordinances. And it's been reported that by the adoption of these ordinances, it deters this type of behavior in their communities. So in response to what we have heard at the city council level, of Councilwoman Perez as well as Councilwoman Basua requested that staff bring forth a proposed anti-harassment ordinance that looks to address some of the concerns that are being heard, that are taking place in the community and from what we're hearing from the community. So in preparation for this ordinance, staff engaged our outside legal counsel, Stephen Lewis, Mr. Stephen Lewis, who has over 30 years of rent control experience. He's worked for the cities of West Hollywood, Santa Monica. He's very well versed in all things rent control, anti-harassment. We tasked him with helping us draft an ordinance. He really analyzed multiple ordinances throughout the state and really put forth a ordinance that is really leans on a lot of the best practices, as well as does not violate any constitutional protections or any published court opinions. In a nutshell, the proposed ordinance prohibits harassment by residential landlords and identifies specific acts and omissions by landlords that constitute prohibited harassment. Violations under the ordinance are a misdemeanor and may be criminally prosecuted. The ordinance also allows tenants, the city, or an organization to pursue civil action for damages and the recovery of attorney fees. And furthermore, this ordinance would apply to citywide to all residential tenancies. Moving forward, so there's multiple approaches to adopting this type of ordinance. The approach that was recommended by Mr. Lewis was this ordinance be a standalone ordinance, so not baked into the city's rent control ordinance, not baked into the tenant protection ordinance, a standalone ordinance. By doing so, it allows it to apply to all residential tenancies throughout the city, not just those that are covered by rent control, not just those that are covered by the tenant protection ordinance. When looking at that approach, the one jurisdiction that takes that approach is the city of Santa Monica. So we really took a deep dive into their ordinance, try to understand how it operates, the staff level, and which is in the report. You'll see that it's really enforced by their city attorney's office. There's roughly about 33,000 renters in the city that this applies to in Santa Monica. And the unit is staffed by five attorneys and 2 investigators who really carry out the day-to-day operations of the enforcement of this ordinance. That unit does do other functions outside of the anti-harassment ordinance. So I just want to have that caveat. They just don't only do anti-harassment ordinance. They do a few other, enforcement of various city codes. A little bit more about how the process works in Santa Monica. There are online complaints that are issued. An investigator investigates those reports, those claims, interviews clients, interviews tenants, does investigation, takes photos, and then prepares a report for the city attorney to review. And then at that time, the city attorney makes a decision to potentially, take further action, whether it's litigation, education, various methods to try to enforce the ordinance. With respect to how the city of Oxnard, if adopted, how the city how it would impact the city's operations, it's estimated that there's about 22,000 rental units that this would apply to in the city of Oxnard. Adoption of the ordinance would result in a significant expansion of work for the housing department. Just to handle the number of calls that we would be receiving, of course, the complaints, the investigations, and then obviously the impact it would also have on the city attorney's office to vet those complaints. So in order to really have an effective program, staff is recommending additional resources by way of an additional partially dedicated city attorney, as well as a fully dedicated housing investigator. And that really concludes an overview of the staff report. And with that, we can answer any questions you may have. We have all of our city staff here, as well as I believe our outside legal counsel, Stephen Lewis, is also on the line, who can answer specific questions regarding our ordinance.
Wonderful. Thank you, Mr. Ramirez. We're going to deviate a little bit from the traditional way that we do these types of.
Gosh, I hope they can't see me.
We're going to make this a workshop type of hearing, allowing us to just go through the document together with the public speakers that are here that are going to be able to come up, and we can just take one item at a time and go through it and just take your input if you should have any as we move through this document, so that we can get some good robust discussion on it and make some recommendations and have some commentary up here ourselves as committee members. Before we start, Councilman Pearl, you want to say something? Go ahead.
Just for the record, I have received communication from Cause, and I've received Barbara Macri-Ortiz, a letter from Carl Lawson, and spoke outside to Manuel Herrera. I do have one question of legal staff. If any of us are owners of residential property, apartment houses, condos, whatever, within the city limits of Oxnard, does that prevent us from sitting in on this item?
The short answer is no, because of the great number of residential units within the city. It's the public generally exception.
Thank you
So
very
you may
much.
participate.
Thank you, Mr.
Thank you, Mr. Rizzo.
Mayor, if I could, I just wanted to make a quick comment before we proceed with our workshop, if that's
Absolutely.
okay.
Absolutely. Go ahead, Mayor.
Thank you. I first wanted to thank our housing department for your work on this effort. As mentioned, this ordinance came out of a lot of the discussions that were had, particularly in District 6 and throughout Oxnard, the importance of ensuring that our tenants have the protections that they need, especially in this critical time that we are in at the federal level. I also wanted to highlight that I appreciated you highlighting other cities and jurisdictions that already are well on their way of implementing this ordinance. And I just wanted to highlight that the city of Santa Monica receives about 200 complaints a year, and on average, 5 to 10 of those result in litigation, and each of these complaints warrants a thorough investigation. And I really think that it's important that we ensure that our community members have due process and are able to participate in engaging in their rights when it comes to housing, and ensuring that our community here recognizes the importance of ensuring that our tenants are protected at all facets. So I just wanted to make that quick comment. Thank you.
Yes, Councilmember Perlow, go ahead.
I appreciate Councilmember Perez's comments. I would just like to point to the audience. We heard that Santa Monica was 33,000 rent units. As of last night, checking on the internet, 2023, the population of Santa Monica was 89,900. Here tonight, we're hearing 22,000 units, population of Oxnard, 207,000. Just keep that in mind. Thank you.
Thank you. And if I can just get some clarification from Mr. Roselle and from our city manager, should I just go through the proposed ordinance and then just go through the various sections and then just have speakers come up, like Maria and also Macri Ortiz and others that want to chime in on some of these? Is that the best way to go about it for the workshop?
I think there's two things that we can do here. First, on the one, now that we've taken them out of order on this, the D2, we had 2 letters submitted, and in total, that raises 4 points. Because one of the letters repeated, so Cause has 3 points within their letter specific to this ordinance. Barbara Macri Ortiz had 2 points, one of them being the same as Cause. Staff, in consultation with Stephen Lewis, does have responses. One of them, we agree that a change should, it's the one that both Barbara and Cause submitted. We agree to changes there, and we're ready to recommend that language to you. So I don't know that the workshop format is as needed for this one. However, we have not heard from the real estate side that is also here tonight as well, that they may have some other points that have not been yet brought to our attention. So I do think the need to take public comment before we maybe get into all the changes and the back and forth is probably warranted. If the city clerk has already provided that list of speakers, I would actually defer then to you, Mayor, and to the Cause and the number of speakers that they have of how they want to address their points. But we are ready to address the 3 points that they submitted on this letter, as well as the 2 from Barbara Macri Ortiz.
All right, well, thank you, Ms. Golden, thank you very much. So with that, we'll go with the public speakers. Mr. Walter Morris, if you want to come up.
Nothing like going first. Good evening.
Good evening.
Thanks again, or good evening, and thanks again, Chair and members of the committee. My name is Walter Morris, and I'm here to speak with you as a resident of Oxnard, as well as the first vice president of the Ventura County, or Ventura Coastal Association of Realtors. That being said, we absolutely recognize the importance of privacy in small minorities of bad actors in our industry sometimes abuse their position, and our association fully supports and holds them accountable at the same time. We must ensure that the responsible housing providers, those who are doing their work diligently, also have the right of way and are definitely disapproval of impacting of overly branded regulations. State law specifically requires housing providers to document a property's condition with photographs of both move-in and move-out for both the state as well as insurance purposes. Often required documents eventually maintain coverage. To comply with these regulations, owners typically conduct a couple of regular inspections, property inspections each year, which benefit both the housing providers and the tenants by promoting a safe living environment as well as maintaining the property. We encourage the council to add clarifying language to the compliance with the state and the insurance companies. These are new laws that have just come out, by the way, with the photographing. Without careful crafting, clarifying language, well-maintained measures could unindictedly increase and restrict the ordinary legitimate tasks that consistently housing providers to carry out and create yet another barrier. We urge the city to add clarification ensuring that while we protect tenants from real instances of harassment, we also preserve the rights and obligations of property owners in responsibility of the managers and maintenance of their properties. Clarification should also be added as outlining unacceptable behavior from tenants. As unacceptable as it is for housing providers to harass a tenant simply by living in their home under the terms of the lease, it is also equally unacceptable for the tenant to harass the housing provider for simply enforcing the terms of his lease as well. These clarifications will create certainty that we will keep all the city's housing stock safe and well-maintained. In closing, our association remains committed to being part of the solution, but we also stress the real solution comes from collaborative, data-driven policymaking. We ask that the city to work with us and all the stakeholders here in Oxnard to craft, update, and truly address the problems without creating new ones. We are ready to work alongside you in our crafting ordinances to promote dignity, fairness, and a saving housing for all. Thank you very much for allowing me to speak. It was kind of interesting because it was my first time as well.
Thank you. You did great. Thank you, Mr. Morris. Mr. Julio Gomez.
Good evening, Mayor, City Council. My name is Julio Gomez. I'm a real estate broker. I have a property management, and I have 122 landlords, house providers, 350 doors in Oxnard and Ventura. The reason I'm here is because when I read this anti-harassment issue, I think they had to listen to the other side too. When we go to houses to request inspections, to protect the assets of the landlords, we always find sometimes some kind of reject, because sometimes tenants, they don't always tell how it is the truth. You have a contract that you had to sign, and you had to follow the contract guidelines. For instance, if the contract says only 3 adults and 2 children, and then we will go to the house and we find 5 cars parked in the front yard. When we find a lot of people in the house and we request that we're gonna come back, they get upset and then they say, we're gonna call the city because you harassed me. We're just doing our job. We protected the assets of the landlords. Most of my clients, they're pops and moms. There's the retirement properties. When they get into retirement age, that's what they have. So I think what we have to do is create some kind of ordinance to be equal to landlords and tenants, not just the benefit of the tenants, because there are no good tenants out there too. So it's not just landlords. Believe me, there are no good tenants. We had to go back and say, you need to fix the house. We leave you this way and you had to keep it that way. Even for safety. Sometimes it's a lot of trash in the front yard and the backyard. We request to clean it, they don't do it. So when we come back, and then they say, you harass me. So it has to be a way, a balance to help each other. We're here to help the tenants, the community. We know the crisis of housing. We try to do our best, but we need also the help from the city to try to resolve this issue. Thank you.
Thank you. Thank you, Mr. Gomez. Maria Navarro.
Thank you. And good evening, council members Perel and Perez, Mayor MacArthur, and city staff. On behalf of CAUSE's Adult Committee, and the tenants present here today, we sincerely thank the council members and city staff for listening to the tenants who expressed their concerns regarding retaliation and harassment to the city of Oxnard at the January 7th meeting. The tenants from 3 different apartment complexes then shared specific instances of harassment which occurred after the tenants had exercised their rights by either submitting a complaint of an above-cap rent increase or after calling code compliance. These tenants understand that their actions, even sitting here today, can lead to retaliation. And in fact, it has. In one instance, a tenant received calls in which the landlord's agents asked about the tenant's immigration status in an attempt to intimidate the tenant and his family into vacating the rental unit. This is after the tenant called code compliance, who yellow tagged the unit due to mold. Thankfully, the tenants were able to save their tenancy and return to a remediated unit. In another instance, some tenants successfully filed a complaint against their landlord for an above cap rent increase. However, this instigated months of harassment, where the landlord offered multiple buyout offers and threatened to initiate eviction proceedings with no legal basis. Those tenants, unfortunately, after months of harassment, decided to leave. Recently, one tenant group described the constant harassment and the constant fighting as a war of attrition. And that stuck to me because in this war, the tenants may have a tactical defensive advantage. They have the law on their side. But they're up against an opponent which has a great advantage of time and finances. To say that it's exhausting to defend themselves in these conditions is an understatement. What makes tenants leave is not the fact that they don't know that they have tenant rights, but the fact that they are worn down until exhaustion. This is why the tenants here and CAUSE are hopeful that this ordinance will assist in leveling the playing field and deterring blatant acts of harassment. We're not talking about good actors. Good actors don't do this. Good landlords don't do this. We're talking about bad actors. If possible, we ask that the council members consider adding the changes outlined in the letter sent to you yesterday, and that these be incorporated into the first reading of City Council. We thank you for your continued support to the tenants of the city and look forward to continuing this conversation. Thank you.
Thank you. Ms. Barbara Macri-Ortiz.
Thank you. I just want to give you a little bit of context in terms of balance, because when you talk about landlord-tenant, you're talking about the balance of power. And for many years, all the power has been on one side. What's happening now is we're trying to get a little of level playing field or an even. And I deal with many landlords that nobody has any problems with, because they not only follow the law, but they follow the procedures. For many, many years, the only thing tenants ever had was the procedure. And so in terms of the examples that was given by, I believe, Mr. Gomez, they already have their side. If you look at the way the ordinance is written, it's like if you have an issue with overcrowding, you prepare a notice to enter, a 24-hour notice, and then the landlord has every right to go in. And if a tenant is breaking the contract, you prepare a notice, violation notice. That's the due process that the tenant has a right to, and then the landlord has his recourse. And if he's doing it properly, he will win. There probably are some, actually there are some tenants that I know that have been created problems, but in terms of the amount of people I've dealt with over the last 30 years, that really comes as the exception rather than the rule. And when you talk about bad actors with respect to landlords, it's because they don't use the process that they're entitled to use. They just feel like, I own this place, so I can just jump in here and do whatever I want, whenever I want. And that's not the case. And so if the real estate company or the property managers follow their procedures, then you have order. And if you have order, then you don't have intimidation. You don't have a reason for the anti-harassment. And this ordinance, when it's passed, will be used with bad actors, not with good actors. And believe me, tenants love good landlords better than anything. I have clients who lived in the same place for 20, 25 years with the same landlord. Respect on both sides. That's what we're looking for. Gives us the ability to deal with bad actors. And it's time. And I think we can have all the dialogue with the Board of Realtors to get a better understanding. An understanding that is driven out of respect on each side. And see, what we've never had before is any respect on the tenant side. Now we're just making the scales level. And then that will go toward a healthier situation for all concerned, both the tenants and the landlords. Thank you.
Thank you, Ms. Ortiz.
Chair MacArthur, if we can actually go to the virtual speakers to make some comments.
Sure.
So Janet, if you can press *6 to speak on this item. This is on the tenant anti-harassment ordinance.
Can you hear me?
Yes.
Good evening, and thank you for the opportunity to speak. My name is Janet Sprisler, and I'm the broker and owner of Rent 805, and I manage properties throughout Oxnard. I'm here tonight to speak about the importance and the purpose of routine property inspections. Let me start by saying clearly, I do not believe tenants should be harassed. Inspections are not and should never be used as a tool to intimidate or pressure residents. I also believe that inspections are essential for tenant safety, property preservation, and legal compliance. After the recent earthquakes, we've seen signs of damage, cracks in stucco, shifts in ceilings, doors that no longer shut properly. Many residents don't realize these are things that need attention and they don't report them. That's where proactive inspections come in. They help us catch safety issues early before someone gets hurt or a small repair becomes a major emergency. Another reason why we do inspections is insurance compliance. Many companies now require proof, annual photos and documentation, especially related to potential water damage. Without that, a claim can be denied, leaving both property owners and tenants in a vulnerable position. We are legally and financially obligated to stay on top of that, and it protects the people living in these homes. We also inspect smoke detectors, which should be smoke tested at least once or twice a year. Batteries die, devices fail. If they don't work when they're needed most, lives are on the line. We are willing to work with tenants. We even offer video walkthroughs when that feels more comfortable. The goal is cooperation, not conflict, but inspections cannot be treated as optional. They are a responsibility that we carry not only as property managers, but as a part of keeping homes and people safe. Lastly, I want to be clear. Code compliance should not be doing the job of routine property checks. That's our role, and we take it very seriously. When we are shut out from doing those checks, the system breaks down. In closing, we support tenant rights. We support housing safety. We do not support harassment, but we cannot meet our obligations to protect the people we house without access to the job that we're expected to do. I implore you to have us all work together and come up with the right language so that there is not any unintended consequences, but safe housing for not only our residents, but a property that owners can stay happy with and are proud of the housing they're provided to their tenants. Thank you for your time.
Thank you for your comments.
The next speaker will be Matt. If you can press *6 to unmute, and you can start now.
Okay, can you hear me?
Yes.
Okay, thank you. Thank you, Council. Appreciate having the opportunity to converse and have an open dialogue about this important issue.
Thank you.
As a housing provider over the last 35 years, there are exceptions to every rule. And many of those have been brought up this evening. But the question is, in reading this anti-harassment ordinance, I think about myself as a small operation, and many of my owners that have tenants, many of them for multiple years. But because of an ordinance like this, it just seems overly harsh and punitive. In that, as a housing provider, I'll almost have to have, for any issue now, recommend that the owner hire someone to answer any cause because of the way this ordinance reads and because of what a tenant might do. As a guy that had a rental and had a tenant that harassed me personally, it's nothing to live through. I mean, calling the city inspections, making up things, making up emails and sending them to me, it's maddening, the process. So I want you to think about the small landlords because without them, this city will not be the same. We won't have the opportunity to have long-term tenants. We'll scare people off who really want to do the right thing and have done the right thing for many, many, many years. This is not, these things that are being brought up tonight are the exceptions. And tenant harassment for those that are practiced for years and years and years, that's just not any kind of question. It's just not any way we operate. So I implore you to remember the small landlords that make the city what it is and provide housing and have done a great job, because they're not here to speak tonight. I'm here as a representative and a guy who always wants to do the right thing. I appreciate the opportunity to speak. Thank you.
Thank you for calling in and for your comments.
We'll move to the next caller. Cami, if you can press *6 to speak on the tenant anti-harassment ordinance, starting now.
I would like to speak to the second agenda item, please, and not to this one. So I'd prefer to come back later when we address that one. Is that okay?
Yes, thank you. We'll move on to the next caller ending in 3259. You press *6 to unmute. You can introduce yourself if you'd like, starting now. Caller ending in 3215.
Hello?
Yes.
Yes, hi, this is Deirdre Frank. I would like information about what the state laws already say about these issues, whether or not they're subject to unlawful eviction defenses. I don't understand why we need something like this when there may be civil remedies already available to tenants who are harassed. I heard the statistics about Santa Monica, that they have 5 to 10 cases in Santa Monica. Is this worth $500,000 that the city is going to commit to hiring additional city attorneys and investigators? I just don't think this has been looked at sufficiently to put an ordinance in place that would require this expenditure and this effort. I appreciate the problem, but I think there's already civil remedies available to address the issue. Thank you very much.
Thank you, Ms. Frank, for calling in.
Chair MacArthur, that actually concludes our speakers virtually and in person. Thank you.
Thank you. Is there any comments from the committee members on what's been discussed here so far? Mr. Pearl, anything, or Councilwoman Perez?
Yes,
Yeah.
if it is okay, I would like to just make a comment. Thank you, everybody, for having the opportunity to come and speak with us tonight. And for those of you that are here in person, I would like to recommend, I did receive some amendments, and perhaps maybe we can get some clarity from our attorneys regarding how to move forward. But I would like to recommend that we move forward with some of the amendments that have been proposed to us tonight.
And just for clarification too, Mrs. Golden, which item did you say that after consult with the attorney that we've hired, he was agreeable to make some modification? Which point was that?
So for this item before you, there is one recommendation from both that was repeated in both Barbara McEorty's and Cause's letter, that we have not their proposed recommendation, but we have some language that we think can address the concerns that were raised, that was regarding the,
Is that the good faith?
that is item 1, where Cause put forward to delete the last phrase of section 27-42A10. And in their recommendation, they were requesting that we strike the last part that says, or in good faith contemplated when the threat is made. And we have language, and I can have Elle read that into the record of what we would propose that we feel addresses that concern. So maybe we can handle the different items separately, and on this one, unless there's a comment from Councilmember Perello specific to this 27-10 as well. Do you have general comments that you'd like to make before we get into each item? I guess is what I was looking to Councilman Perello for.
In reviewing the information, we got a combination of items 1 and 2, and I know there's a mix, but various people that I hold in high regard. It sounds like there still should be some work done on this. I would not be opposed to sending this back to the housing department, get everybody involved, iron it out before it comes back to the city council. We're making sausage here tonight, and when it comes back to the city council, we might be making chorizo or salami or something else. It's not funny, because this is people's lives. There are a lot of issues. I'll be very blunt. This doesn't go over good with this crowd. Former Mayor Pro Tem Brian McDonald asked numerous times of an individual from Cause named Louis Zucker, when they would bring up people and bring up conditions that the people were living in, and asked them, give us an address. They wouldn't do it. Another time they brought it up, and I called Mr. Zucker out. He didn't like it. I appreciate what Cause does. I appreciate what Cause stands for. But I also appreciate the fact that when we send something to the full council, we have a finished product. I highly respect Barbara McEorty. She's been doing this a long time. We're not always on the same page, but most of the time I know that she's doing what she feels is right. I think I'm doing what I think is right by asking the parties to get together. When this comes back to the council, I would assume, and we know what that makes of people, there would be twice as many people here expecting something to happen. We received the copy, multiple pages from Cause, a couple of pages from Barbara, some comments, and some people have showed up at 8:30 at night, which is not normal. Normally this meeting, very few people show up. I do not think it would be unwise to have the people get together with our housing staff, consider their views before it gets sent as approval of the first reading to the city council. That's my opinion.
Can I add a comment really quick, if that's okay? I know for D2, that is, there's just recommended amendments. I think it's D1 that has more of the fleshing out to do. So if we can focus on what those amendments are for D2, 1 and 2, that would be great.
Yes, so if we want to go down the list, starting with Cause's letter, the first item, as I indicated, we do have proposed language that we think can address the concern that they're raising, and I'd like to turn it over to Elle, and also Stephen Lewis is on the line and can chime in as well.
Thank you, Committee Chair. Elle McCarron, Assistant City Attorney. Ms. McEorty and Cause, they do raise some good issues in terms of the term good faith. It is vague, and I think it can be misconstrued. And the purpose that that language was serving in this ordinance was to protect the city from violating Civil Code Section 47, as well as the California Supreme Court Action Apartment Association versus City of Santa Monica. A very similar prohibition on certain communications and conduct by landlords was found to violate the widespread litigation privilege. It actually stifled landlords from being able to undertake allowable conduct and communications in preparation for litigation, as well as send out notices and discovery requests for actual litigation. So what we would propose is to change that last sentence to read as follows. This subsection shall not apply to communications and conduct that are made in connection with actual pending litigation or litigation preparation, including any communications and conduct subject to Civil Code Section 47, in conjunction with the good faith requirements stated in Action Apartment Association, Inc. versus City of Santa Monica, parentheses, year 2007, and then it gives the Supreme Court site, which is 41 Cal 4th 1232. So that is our proposed fix. And we believe that will I don't know if that will satisfy Cause and Ms. Ortiz's concerns, because we are providing an additional layer of protection potentially here to the landlords. But what we're doing is insulating the city from litigation liability from landlords here. So, and it takes out any of the confusion. So I believe this should satisfy all sides.
Thank you. Maria, I don't know about Mac-Ortiz, does that sound reasonable? Is there any commentary on that?
No, that works, because it just adds more. I think that works perfectly, and it's basically what I said with the, how'd you say, all the trimmings.
Okay.
But it works,
With all the
thank you.
trimmings, okay. And
Moving on to item 2 then,
Yeah.
Mayor, if you would like us to go through that. This is one from, and item number 2 from Cause is looking to add unlawful or excessive rent increases, a clause which was recently added to Santa Monica's ordinance. One distinction I also would like to make with Santa Monica is they are a charter city. They are not a general law city. So we also had Stephen Lewis look at general law cities, West Hollywood being one of them. But I think in this one, I'd like to turn it over, if you're able to unmute Stephen and talk to the reason that we would not recommend this addition to our ordinance.
Good evening, everyone.
Good evening.
It is unlawful with respect to rent-stabilized units, the units covered by statewide rent limitations, and of course, units that are subject to rent limitations due to an emergency declaration, or units that are covered by a contract, for example, inclusionary units, to increase the rent by more than the amount that's stated in that contract or set forth in the law. And there are remedies provided by those various modes of limitation. For example, in the case of a rent increase that exceeds what is permitted under the city ordinance, there's a process for tenants to come to the city and get a remedy for that unlawful increase or increased notice. It's not clear why an additional layer of protection is needed. People can make the case that they wish to, and it's up to council to do that if they wish. But because there is already a protection, we have not recommended one, an additional punitive measure by the city. With respect to units that are not covered by such limitations, the notice of increase that may exceed what the market would generally bear is not unlawful. It seems problematic from a variety of perspectives to impose a punishment, whether it's civil or otherwise, against an owner for making a rent increase that is not otherwise unlawful. If there is a problem with an increase that is beyond what the market would bear, there are other means of addressing that, including making such such increases unlawful, which the state has chosen not to do, and in fact, in many cases, has expressly prohibited cities from imposing such increases. Given that the city cannot impose rent limitations on, for example, newly constructed units, it's not clear that it would be permissible for a city to impose a penalty for an owner increasing rent by an amount that the city can't otherwise control.
Thank you, Mr. Lewis.
Open to any questions if anybody has any.
Is there any questions?
Sure.
Yeah, go ahead, Mr. Barlow.
The way you have described it, I appreciate you being there, and I appreciate you taking time from your schedule to be here and help us. Where is the variation between what the state law, minimum or maximum, address compared to what you are describing?
I'm not sure that I understand your question.
The movement that we are making, the suggestions that are being made by the various organizations, compared to the current state law, when people are found in violation, where is the distinction? Where's the difference? Is there none?
I think you're muted, Mr. Lewis.
Oh, I'm sorry, thank you. I'm sorry, I'm still not entirely sure that I understand the question. The state law, for example, with respect to units that are not exempt from the limitation that state law imposes a limit of the increase in the rate of inflation plus a specified percentage up to a maximum of 10%. That limitation applies to units that are not specifically exempt by state law or that are not covered by a local ordinance. But with respect to units that are not covered by such a limitation, there is no limitation. An owner can increase the rent and a tenant can choose to pay it if they wish or not.
Councilmember, I think one of the distinctions, it's not so much in state laws, it applies to the total, it's in what units do they apply for. So when CAUS put this one forward, their justification in this is really to get those units that are not covered by our just cause ordinance in the rent stabilization ordinance. And I think that's this distinction that Stephen Lewis is trying to say there, is that's kind of not tested. Is that the right word? When we spoke earlier, Stephen, to talk to that of the approach that we've taken thus far with council, this discussion started back in 2021, is kind of a go slow, use tested models. We weren't big on litigation. We weren't looking for things that had not been tested by other cities. And this approach here that Santa Monica just put forward is not a tested approach, widespread in all the research that Mr. Lewis has done. Like we said, this was just added about a year ago into Santa Monica's ordinance. And the concern being raised that applying these to units that are not already protected by just cause and rent stabilization, which is what he was talking about, or other regulatory, we also have affordable units. Those do have limits on how much you can increase their rent, regardless if they're within that, is the right time period, 15 years? The 15-year time period. And so that's the distinction that he was really trying to get to there. And I think that's the distinction CAUS is doing, is what about those units that aren't protected by rent control, by those 15 years? What kind of protections do we have that they can't increase the rent? And the response is the market bears the rent in some of those. That law does not exist at the state level right now. And Stephen, maybe that gets us kind of back on the right track to be able to address the council member's question a little bit deeper.
I'm sorry, yes. When state law has specifically declined to impose a rent limitation, in other words, where an increase is lawful, it seems problematic to punish an owner through an anti-harassment ordinance for imposing such an increase.
This is contradictory.
Okay.
Thank you, Mr. Lewis.
Thank you.
Thank you.
I have a question. I know we are referencing the city of Santa Monica having this in place. Is there any other cities that we know of in the state of California that have this in place?
That have in place making it a form of harassment to increase the rent by more than the market would otherwise permit?
Barbara?
Is this something that would require further investigation? As a part of your research, was that something that you looked into as well?
I did not. I didn't specifically survey other cities to see that if they have that. I have worked on and written many cities anti-harassment ordinances have not seen that. Although many cities in recent years, especially since the pandemic, have taken a more robust approach to anti-harassment ordinances. But no, I have not specifically looked into whether any other cities than Santa Monica have recently enacted such a change.
And I would say in alignment with that, the approach that we've continued to take is we've come back and we've amended the ordinance. So the council adopted the ordinance in 2022, and we've already been, not this ordinance, but the just cause rent stabilization. We did already come back and make an amendment to that because of the partnership that we have with both sides in this, of hearing the actual issues that are out there. And I think if we can continue to look at this as progress and getting in as we collect more data and see what issues we come across, we can always come back and add more. What we're really trying to do here is get something in place so that we start to offer some level of protection sooner rather than later. So again, this is a newer one, and as Mr. Lewis indicated, he has written these across the state, and some cities are getting more aggressive. That just has not been the practice of this council so far, and it's not to say that we couldn't go there, but our recommendation would be kind of the start slow, get in progress, get something in, continue to collect data and the partnerships from both the real estate side, the owners, and the tenant side of ways that we can make this better. So that would be our recommendation.
I appreciate it. Ms. Golden, Councilwoman Perez, anything else? And I just also want to make sure I don't know if Maria or you or Barbara have any commentary after hearing what Mr. Lewis explained for the rationale.
Sure. And I just want to thank Mr. Lewis for explaining that. I think that makes total sense. And I understand that, it is a new law and it still has to be tested, right? I guess the intention of this addition was for specifically the protection of single-family home renters who are not protected by state law, right? And those are folks who we've seen have been living in the home for like more than 20 years, have been rented, have had a good relationship with their landlord, but once the landlord dies, the state takes over the home, and usually that means there's a substantial rent increase or an attempt to an eviction in violation of our just cause ordinance that then leads to rent increases, which we've seen in some examples go from like $2,300 to $8,000. And so for a retired couple or a retired mother, it's just really, really hard for them to meet that. So that was the intention behind that. Understandably, I mean, there might not be any, I guess, state precedent for this. So if there's not, then there's not, and we'll let Santa Monica handle the litigation.
I appreciate Maria, thank you. And I think to Attorney Golden's point, I think we're making progress. Nothing says we can't go back later and revisit and move forward, but we are making progress. Okay, we'll go to...
Chair MacArthur, yes. Janet would like to just add a few.
Absolutely, absolutely.
So Janet, if you can press star 6 to make a few comments. Starting now.
Thank you. Janet Sprisler again. I believe what you're looking at is going against the Costa-Hawkins Act, which provides protections for single-family homes and 2 or more units where the owner presided there prior to the resident. For those units that are going from $2,000 to $8,000, that may be looked at in what is already in the books, because it does say that if you're going for a certain amount, if a tenant feels that that's retaliatory, they could bring that to the city housing division, and then they could do a prove-up of how they got to that market rent. Between, I think there's like a mediation that can happen there between the single-family homeowner and with the resident based off of what Oxnard already has in place. But again, Costa-Hawkins does have a stand on this already.
Thank you for your comments. Any additional comments? If not, we'll go to number 3.
Okay, number 3, this is related to a buyout provision. And one just difference I want to point out with Santa Barbara is that they don't have rent control, they have the tenant protection. And we actually have a staff person that has some experience with that. And I wanted first, before we turn it over to Stephen Lewis, if Alba Marshall can give some experience. She is the program manager for this and has the relationships again with both sides and has been our staff person consistently implementing this ordinance for the last couple years. But Alba, if you can give some context of Santa Barbara, and then again, we'll turn it over to Stephen Lewis for the legal side of why we would not recommend this addition.
Yeah, so I originally came from the city of Santa Barbara. I was part of their program, their mediation for landlord and tenant rights and responsibilities. And one of the trends that was seen for the city of Santa Barbara, thank you, was that there was a buyout or various buyouts that were happening in the community. And it's a different demographic, but because there's no rent stabilization ordinance that's in place, the owners were utilizing this method to kind of terminate tenancies and then just set them back to market rate rent. So it's a little bit different than our current cities and what we've seen in our community. However, Stephen can add a little bit more information as well as why, staff is not recommending we take this at the time.
Thank you. I think it's
Stephen.
Mr. Lewis.
Yes. It seems to me to raise potentially First Amendment problems to impose a punishment against an owner for making what is otherwise a lawful offer. If the means of making such an offer is otherwise harassing, that would be covered by other provisions in the ordinance. At this point, there's no evidence that I've heard of that such a thing is happening in the city of Oxnard. If it does, the city could, of course, revisit that. But it does seem problematic, given that it is lawful for an owner to offer money for a tenant to move, to say that making such an offer, absent some other coercive activity, is subject to punishment by the city.
Yeah, thank you, Mr. Lewis. Any follow-up by Barbara Maria on that? No? Okay. Yes, Mr. Parlo, go ahead.
A question, sir, on your comment, other activities. What do you mean by other activities? Can you define it a little more?
Yes, for example, threatening behavior, physically threatening behavior, other activities that are already, that would otherwise violate the anti-harassment ordinance as proposed.
Thank you.
Thank you. Thank you, Mr. Lewis.
So that concludes the 3 items in causes letter related to the anti-harassment within Barbara McElroy's letter. Her first item is related to adding a paragraph that would better define or would define times and express consent for landlords being able to enter the home. And I'm not sure which attorney wants to kind of take this one. I'm going to look to Elle first, and Stephen Lewis as well jump in. Or maybe we'll start with Mr. Lewis. But again, this is one that we would not recommend this. We actually feel that it limits potentially getting help to the tenant sooner, as well as the landlord. And we actually have Brenda Lopez in the public housing side that would have issues if this was placed upon us as a public housing entity, of limiting us to just an 8 to 5 Monday through Friday. There are times when that would be problematic, when we would actually want to be responding and addressing issues within the tenant. So we could also have Brenda Lopez speak to the experience as us as a government agency. But first, I'll turn it over to Mr. Lewis.
We're talking here about the times of the day during which an owner could enter a tenant's unit after giving proper notice.
That's correct.
That's correct. And I'm sorry, I just realized Mr. Lewis is on a different time zone than us, so he may not have seen the exact language here. So sorry to put you on the spot. If you need one of us to handle that, we can do that.
No, that's all right. It does not seem problematic to to require that notices specify that the owner will enter during some time that is a normal time during business hours, if it's possible. But obviously, there are times when that may not be possible in the event of emergencies or other such things. So I would think that a rule of reason should apply there. But I have not seen the proposed language, so I can't comment on it further.
Committee members, if I may, Elma Karen. The express consent language and the actual listing of 8 a.m. to 5 p.m. Monday through Friday may run afoul of Civil Code Section 1954, which lays out how a landlord can go about giving notice to enter into the property. An express consent is not required under there, so we would be doing something more stringent than what is required under the state code, and that's arguably preempts what is put in here. And also, just from a practical standpoint, there may be things that need to be fixed on a Saturday or Sunday, and we don't know what a particular landlord's business hours are, particularly, so to limit to 8 to 5 might be difficult and inflexible, because maybe the tenant isn't there in between 8 and 5, and they would prefer somebody to come when they're home after 6 p.m. If we are to look at this issue in the future, if it becomes an issue, we could maybe put in something like, hey, you can't come and do these repairs upon 24 hours notice in between the time period of 9 p.m. and 6 a.m., so that we prevent harassment if that seems to be the route that they're going to go down to use inspections to bother people. But this would be very restrictive and more likely in violation of Civil Code 1954.
Thank you.
I have a clarifying question in reference to this item. Just seeing here some of the comments around landlords coming in to households at a late time, and I know you mentioned that emergencies can happen. Would we be able to include in the language, unless an emergency occurs, that they are able to come in at a later time outside of these parameters here?
Civil Code 1954 allows for that, and so does our ordinance. And typically, if there's going to be an emergency, I would assume the tenant has called to notify the landlord. Yeah.
So to be clear, the language that was recommended by Barbara Mac-Ortiz, we are not suggesting any of it go in because of the Civil Code 1954. And the biggest part of the language that was proposed that was of concern to the city attorney's office was the term without the expressed consent of the tenant. I think there's feedback that we can get from the tenants going forward, again, of what hours, what are we doing, and as Elle indicated, maybe looking at it not in the normal business hours, but kind of having those precluding hours, not after 9 p.m., the other way to give some more flexibility on both sides, but as drafted right now, and again, trying to not let perfection get in the way of some progress here. The express consent of the tenant is the part that gives us the most pause from a legal standpoint.
Okay, thank you.
Brenda, do you want to add any of the experience from the public housing side?
Yes, so from the public housing side, the concern that we had is, number one, asking for the expressed consent of the resident, and then also assuming that business hours are 8 to 5 for all agencies. In our case, our staff could start as early as 7 and be there as late as 6:30, depending on how many work orders we get and how urgent they are in nature. So on our case, I think what we believe will be fair to the resident is that we are required to give that notice in advance. So staff would not be entering a unit without giving proper notice, again, unless it's an emergency repair. So that's why, at least even from us managing properties, we do not recommend adding this language as expressed in the letter we received. But again, as Ashley mentioned, if we see this issue as we are going through and we get cases, by all means, we're open to revisiting. Even on our end, this will be a challenge for our staff. And then we'll also work on Saturdays. So this would not work even in-house.
Thank you. Ms. Lopez. Go ahead, Mr. Parlo.
Ms. Lopez. the hours that if there's an inspection, you give them a window? What is the window again?
Correct. We usually try to give a 4-hour window, but sometimes we have to give as much as 8 hours. And not related, but related, we also get inspections from the Department of Housing and Urban Development, and they ask us to give at least an 8-hour window. So for an inspection, yes, we do give proper notice in advance. But yes, and we sometimes cannot specify the exact time. So we'll say between 8 to 5, 8 to 6, but we do give a window.
Thank you very much. I can share with the public, when I did rent apartments, if something were like that, whether it inspection or cable or phone, and you had to have an 8-hour window, that meant I had to give up a day's work. And where I worked, if you didn't show up for work, you didn't get paid. You didn't get that. And it's some jobs, and I can imagine it's not too much different now. A person's got to give up a day's work. You don't get very many times before now you just lost a job. So I can see where possibly going a little bit further to accommodate both sides might be beneficial, but it's just facts of life, and I experienced that, and I appreciate that, but I wanted to share that with the public. It's not something that I hadn't experienced, because I do know people that have lost jobs waiting around for somebody to show up. They go back, and the employer goes, I needed you. I had a 2-man crew. My other worker showed up. You couldn't. I need somebody I can count on. Thank you.
Thank you, Mr. Barlow. Go ahead. Ms. Golden.
So those are the letters that we received ahead of time. There were also comments that we received tonight from the property owner and property management regarding clarifying language that they would like to see added for their right to come in for inspection. We've briefly looked through the ordinance, trying to pinpoint which part they're thinking is not clear. If we can maybe give them the opportunity to speak to the section of the ordinance that they're concerned about, we may be able to address that this evening as well.
Sure. Mr. Gomez or? Oh, yeah, absolutely. Yeah, come on, Barbara.
Yeah, I think, I don't have a problem taking out express, just without the consent. I've worked a lot with 1954, and I think it's really being stretched here a little bit beyond what the intent is. I would say, in terms of business hours, 7 to 6 or 7 to 7. I don't have a problem with that. The problem I have, and I have been dealing with tenants for the last 30 years, and the problem is, again, we're talking about the bad actor who comes in and thinks because it's his property, he can go park himself there whenever he wants. That's what we're trying to avoid. And I think the way I would use this, if this was in this ordinance, if I had a client that had a problem with a landlord like that, I would send the landlord a letter and I would say, look, this is what the ordinance says, and you need to respect it. And so it gives a little bit more authority to be able to unwind the thing. But if any of you could appreciate having a landlord come into your house after hours, you're trying to serve dinner to your kids, and they're just hanging out. How do you get them out of the house? With this ordinance, I think this will help also because because basically they're trespassing, but if we have an ordinance, then we can call city police and say, hey, this is what the ordinance says, this guy will not get out of the house. In terms of for repairs and all that stuff, obviously, and we could even say, except in the case of emergencies, where we have life or property, or when repairs need to be made to the property that maybe aren't considered emergencies, but the repairs that need to be done. But you're absolutely right, Councilmember Perello. I've had people very frustrated because they get, the law just says you give them a 24-hour notice. So these people get a notice saying, oh, tomorrow we're coming over. They don't say what time. If you don't have someone who's really communicating with them, then they know, well, can I go? Can I stay? What can I do? We need, again, I'm saying we're getting to a point where we need to balance the scales. It's just give a couple more tools in the toolbox so that we can do that. And I think we can massage the language where it can meet the needs of everyone here. But just, we need something so that it's changing the culture, okay, for certain bad actors. In my book, bad actors. And the realtor's book, it's just people who don't know. You know, it's my house. I can go in there anytime. No, not when you've rented it. But, you know, how do you get that message across? So expand it, whatever hours you need, that's cool. But we just need a playing field for that. Thank you.
Thank you, Ms. Ortiz. Ms. Porter.
In a minute of levity, Barbara, I'd like to share with you, when I first got on council, I learned real quick, you don't invite constituents over to the house, because exactly when it's time to leave, they won't leave, and now what do? So I totally understand that.
Thank you. So we're coming up upon 10 o'clock, so without any objection, if we can go past 10 o'clock?
I'll second.
Okay. Madam Clerk, do we need a vote on that?
Yes.
Okay.
Committee Member Perallo? Yes. Committee Member Bettis?
Yes.
Chair MacArthur?
Yes.
And that motion carries 3-0. Thank you.
Thank you.
Chair members, if I may, really quickly.
Yes.
To Ms. Maraki-Ortiz's point, I think what staff can do here is we can look at 2742 subdivision A3, and we can actually flush out the language that's in 1954 and add it to some of these Roman numeral sections that will allow, that will give some parameters without setting specific time limits and restrictions that might run afoul of 1954. I think there's a little bit we can do in between now and committee that I believe will alleviate both sides' concerns here.
Great.
So we'd be happy to bring that back.
Thank you for the cooperative approach. And I know Ms. Golden had mentioned hearing from the landlords as well. I don't know, Mr. Gomez or Mr. Morris, if you have any points to add on your end, if you want to come up. No. Mr. Gomez?
Thank you. In the private sector, when we deal with the tenants, we follow a procedure. We have specific rules. For instance, if we're gonna do inspection, we need 24 hours call. We go, somebody from the office goes and leave the request and handing at somebody in the house. And we go at a specific time. We're gonna be there we try to do it in less than an hour. We're gonna be there, for instance, from 9:30 to 10. We don't try to give taking too much time from them to do the inspections. So this is in the private sector, how we handle the inspections. We even do inspections over the weekend. We accommodate to the tenants. We own our fiduciary to the landlords, but also we respect the tenants' rights and their time. So that's what I want to say.
Thank you, Mr. Gomez. And I think Barbara was talking more about the bad actors as who she was trying to highlight. Just to keep them.
Chair
Yes.
MacArthur, Janet and Matt and Cami would also like to just make a few comments.
Absolutely,
So
yep.
we'll start with Janet, if you can press *6 to unmute, and starting now. Janet, if you can press *6 to unmute.
There we go. There I am. Can you hear me?
Yes.
Okay, fantastic. So on the 24-hour notice, there is actually a timeline, because I agree with you as well. In fact, I don't have time for my staff or any of my vendors to waste anyone's time, ours or our residents, because we want them to get their jobs. They're our clients, right? So we want them to get their jobs. So when you're looking at when people are erroneously spending time at someone's unit, people should not be letting people in without a 24-hour notice. There's no reason why that timeline should not be put on there of when someone is going to get there, because no one wants to waste anyone's time. When it comes to the weekends, those really should be emergency cases, because when a vendor has to come in over the weekend, we're also paying all that extra time and labor. So not that we would not do the repair, but at the same time, if a resident also is saying, hey, I can only do weekends for that repair, that sometimes becomes a little bit harder to manage with expectations of what an owner can afford as well. But I think that there has to be more conversation around this to really tighten, because I know that I would be annoyed if someone came over and thought they were going to spend some quality time with me and my family, what I was trying to eat. So I think that the language has to be tightened up, because I don't think you're going to see that within the property manager side. But maybe the small mom and pops do not understand what they can and cannot do. So maybe that's also education. But I think there does have to be some sort of language. I just don't want that language to be pushed through with not being able to see how it's going to affect the overall folks that are actually doing things that are right. Thank you.
Thank you.
Mayor Stephen Lewis also has his hand raised. Do you want to take him first or the other?
Is this I think this is the consultant we have. Mr. Lewis, do you want to say something?
Yes, very briefly. One thing that both tenant advocates and owner advocates at this meeting have talked about are inspections. State law governs owners' rights to enter tenants' units. It's important to bear in mind that a tenancy is a form of property under the law. You have an ownership interest in your tenancy, not in the real estate, of course, but in the tenancy itself. When one has a tenancy under state law, and this goes back actually centuries in English law, one has the right to exclude all others, including the owner, except under specified by law circumstances. And state law states what those circumstances are. Those are to show a property for sale or for rent to a prospective new tenant and to make repairs, et cetera. One thing that is not listed in state law is an owner's right to enter just to have a look around. It is not specifically permitted by state law for owners just to say, I want to come in 24 hours and just have a look at your unit. The ordinance as drafted would prohibit that. It would hew to state laws specified reasons for entering a unit. So I just wanted to add that point of clarity, since both sides seem to be talking about owners wanting to come in just to do inspection, and tenants, advocates being worried that owners are just going to come in and hang out in the property. On both sides, that is not something that should be happening.
To Matt, if you can press *6 to unmute and start now.
Thank you. I appreciate the opportunity. Again, similar to Janet, I'm in business. Time is money. I set appointments. I appreciate working with the Housing Authority. They do the same thing. They set the appointments. They show up. I don't think we're ever going to reach a point where we're going to fix this for the guy who's going to hang out at his tenant's house. There's no law. There's no way. I think we're reaching for grasping at straws, trying to fix every single minute issue. And we don't even have any numbers to really support that. It's all anecdotal. My landlord hangs out at the house. We don't even have any specificity around how often that really is a problem. The law is pretty clear. And although my heart goes out to the person who has somebody there at the house hanging out, there has to be another way to remedy that. We can't legislate every single item. Thank you for your time.
Thank you. Yeah, thank you for your comments.
That was the last speaker, Mayor.
And this is more of a question for staff. I know Ms. Deidre Frank, and I don't know, Mr. Lewis, if you have this answer, but she mentioned, alluded to how much potential money can be spent by our city in hiring the staff necessary to investigate or potentially prosecute on this ordinance, if should there be a violation, and she mentioned that the number that she has seen is very minimal in comparison to the amount of money that we potentially can invest. Does staff have a number when other cities were consulted or looked into to see how many cases were looked into or investigated, prosecuted during the course of a year versus how much a city spent to do just that?
So the data that Ms. Frink was referring to was the data that Santa Monica is who we actually sat down and interviewed. We looked at their entire unit. How many units do they have? How do they compare to us? So what she was referring to in the staff report is that they receive, out of their 33,000 units, they receive approximately 200 complaints a year, and on average, 5 to 10 of those result in litigation. Each of those complaints warrants the investigation and substantial time by staff to prepare the cases. They also have other methods. So based on that data and looking at our housing stock here, there's approximately 22,000 housing units here that would be subject to this ordinance. And based on that, that's what we would be recommending to add the positions necessary to actually investigate and process these. I think that's the question you're asking.
Right,
so in that we, if this ordinance shall pass, in order for it to actually be effective, you would need to put forward staffing and funding associated with that. So we would be looking for a partially dedicated assistant city attorney as well as a fully dedicated housing investigator that would be the ones taking these cases. This is separate and apart from the rent stabilization and just cause. We have no staffing associated with this now. These are new positions that would need to be implemented within the budget and that staffing allocated towards that. Based on the current salary ranges, assuming a midpoint of hiring within that, that's where the number of $505,000 came from that Ms. Frank referred to.
Thank you. Yes, Mr. Perlo.
Ms. Golden, the number in the staff reading the paragraph, financial impact on this item. Adoption of the proposed ordinance will have a fiscal impact on the general fund, an annual budget, and again, annual budget of approximately $505,000 is needed to support the two positions, budgeted at mid-range of the salaries, including benefits and fixed charges such as workers' compensation, liability, unfunded liabilities, etc. The current salary range for an assistant city attorney is $156,900 and some dollars to $216,000 and $800 and some dollars, and the salary range for a housing investigator is $59,800 and change and $113,000 and change. My point that I'm driving at, if approved as this looks, just from reading what is put by the staff, we're looking at $505,000 per year ongoing, and I would assume there would be increases in these benefits going forward. And it says impact on the general fund. I have had a discussion where it seemed that this possibly would be paid by the landlords. And if it is paid by the landlords, that would, I would assume, be passed on to the tenants. But the landlords have a restriction of only a certain percentage that they can raise. Will that increase, percentage raised, allow for the recovery if this $505,000 is passed on to the landlords in this community? I know that's a hypothetical, but I'm looking at it like that.
So council member, for this ordinance, and I can look to the attorney's office too, because this is newer for us of looking at this, for the just cause and rent stabilization ordinance, we are looking to come back to you within the next couple months to actually establish a fee that would pay for that program. That is one of the requests when we've done the tenant outreach, because that fee outreach has been going on for about the last 18 months. From the tenant real estate property management, it is the ability to be able to pass on a portion of that fee and not have that count within their 4% cap within that. So that is something that we're still working through actually with the rent stabilization and just fee consultant, but for this ordinance right now, we're not looking to establish a fee. So it would be coming from the general fund, but that is a policy question that will be coming before the council in the next couple months. And the the outcome of that discussion could lead to also looking at fees for other ordinances in place. But those are all based on an individual fee study, based on findings, outreach with the community, and other aspects.
That's correct. As of right now, the way that the ordinance is currently drafted, this would come directly from the general fund for these two positions, specifically for anti-harassment. The fee study would cover possible other positions specifically for just cause and rent stabilization.
Thank you very much. One question, if you can help me out here. The annual increase allowed on the property tax in this community, what is that?
Under Prop 13, it's 2%.
2%. Okay, so if we have 2% increase on the property tax, the individual can raise the rent 4%. Half of what he raised the rent is going to pay for his property tax. And if this fee is passed on to a developer, he's going to have less than 2% to fix whatever needs to be fixed in the apartment. Hypothetically, this is not a done deal, but hypothetically, I'm looking at it like that. I could be in left field, but I wanted to share that with.
Barbara, do you have a comment?
Yeah, no, just on that property tax thing, I think you're kind of analyzing it improperly because you take all the expenses, which includes the property tax. The 2% is just of the property tax. It's not of all the expenses. So it is something that goes up, but you know, it's not in terms of my budget and my property taxes. The 2% I pay on the increase of the property tax is the least of my worries. It's all this other stuff, you know, because it's not really that big in terms of the total of what all the expenses are. That's all.
And I appreciate that, Barbara, but if all of a sudden you got to come up with a chunk of change to pay for your share of $505,000, that would be a big concern, I would assume, unless there's a tremendously large group paying that fee. I'm not representing that group. I'm posing that question.
Yeah, no, I'm just saying in terms of when you look at the 4% increase on a rent, and so you take the rent, what's 4% of that in terms of what the increase is? That's what that's tied to.
All right.
Yeah.
Thank you.
Thank you, Ms. Ortiz. Any other questions?
I'd just like to say that I appreciate the clarification that these positions would be coming from the general fund at the moment.
So based on the feedback that I think we're receiving from the community and the council, if I can go through what I believe that we've landed on right now, and then we would need a recommendation if you think that based on what I'll present here is ready to move on to council directly, or if there's still more work that needs to be done. But going through again, CAUS had 3 items within their letter. The first one being related to 24-42A10. It sounds like we have consensus that our proposed change addresses the issues raised by both CAUS and Barbara Macro-Ortiz. They also raised a concern about wanting language from Santa Monica's ordinance about unlawful of excess rent. That is something that we did not recommend, and I believe that CAUS conceded on that item for now. As it relates to item 3, the buyout offer, that also is one that I believe, and we would need the consensus because I didn't have a lot of feedback from the community on this one, but the staff is not recommending the cash for keys aspect that they looked at from the city of Santa Barbara's code. So would we not be making any changes related to that? The final item being the first item of Ms. Macro-Ortiz's letter related to adding language about the hours of entry, and the recommendation from the city attorney's office is to add language in related to the Civil Code 1954. And my proposal on that would be that we make those amendments to the ordinance and then send it out to both CAUS, not both, so CAUS, Barbara Macro-Ortiz, and the Rental Association, those that are on the letter tonight, and give them an opportunity to review the proposal. and then come to council once we have feedback from them. So the draft that you would be seeing at council would then already have the input from both groups. That does not mean that we will get consensus from them necessarily when we send that out, but that we will work for that before we bring it back here to the city council as a whole, if that's the desire of the board this evening.
Would that come back to council at the next meeting, next Tuesday's meeting, or what would be the timeline?
No, we do not work that fast, and we have the sunshine ordinance. So we would be drafting the ordinances that we presented tonight. That ordinance in totality, in both a red line version and a clean version, would go out to both groups, give them a couple days to review that, and then we would follow our normal sunshine ordinance. Right now, even if things went well tonight and then we were going with no changes, I believe that we were slated for the last meeting in April to come to council, just moving from committee to council. So this will definitely bump it to likely a meeting in May, that it would be coming as the ordinance before the council.
Well, I'm prepared to make a motion to direct staff to make the recommended changes and then bring back the item to council.
I'll second the motion.
Ms. Barlow, is there any further comments, anything? Go ahead.
Yeah, I understand that we're, someone very smart told me shooting for perfection on the road to progress is not the best move, and seldom does it work that way. But we're shooting for perfection, but we're making progress. Do my fellow council members think that having the two sides discuss what they want to address, whatever we've agreed, without working with our housing department, and then bringing it to council, do you think that's a better benefit than having them work together, possibly coming back to this body and then pushing it on to council? I'm not challenging your decisions, I'm just sharing my viewpoint on that.
That's a good point, actually, Mr. Pearl. I'm okay with that if we want to do that and not bring it back to the full council and bring it back here.
Well, but there's a motion on the floor, but I just wanted to share that.
I can substitute that motion.
Can I just make sure, Councilman Perrella, were you under the impression that it wouldn't be the three kind of distinct bodies working together? Because what I just want to make sure I understood what you said, that the city wouldn't be absent that. So the city would draft the ordinance based on the feedback that we heard from both sides tonight to try to address both sides, send it out to those groups to make sure that we got what we heard from the body as well as the community this evening. Provided that we have some level of consensus from them, then we would move on to council. If they're down to word picking here and there, that there's not much that we can do about that as staff, but staff would be in the driving seat of making sure that both sides have that, but the driving force behind the drafting of the ordinance is from the city itself.
To clarify, the city does include housing staff. So they're participating the whole time.
Okay, we're having three parties, so it's the city, the apartment owners, and the citizens groups?
Yes.
Okay, all right, thank you.
Sorry for not making that clear. It would be coming from us. We'd be initiating that and coordinating that effort.
And if I heard Mr. Perrell correct, I think he was just proposing that instead of bringing it back to full council is to bring it back here to this committee for one final review, which I can substitute my motion to, because I'm okay with that as well.
If I can say, I would trust my city attorney, Mr. Roselle. What do you think about the three sides getting something together, hammering it out, and coming back here versus going to council, coming back here, and then if we agree, it goes to council?
That is clearly one of the options. My take, though, is that we basically have consensus at this point in time, so it would make sense to go forward to council after there is a reasonable consensus among the parties.
Yeah, I agree with that as well.
Having tremendous respect for.
Okay, then I'll keep my motion as stated. Okay, Madam Clerk?
Committee Member Perallo?
Yes.
Committee Member Bettis?
Yes.
Chair MacArthur?
Yes.
And the motion carries 3-0. Thank you.
Thank you. We'll now move to the next item on the agenda is item D1 from the Housing Department. The subject, just cause evictions and tenant protections. Just cause, code amendments and resolution establishing administrative regulations to implement the rent stabilization and just cause ordinance. The recommendation that the Community Services Public Safety Housing Development Committee review and the proposed ordinance that will amend the Oxnard City Code regarding the just cause evictions and tenant protected ordinance, and recommend that the City Council approve the first reading by title only and waive further reading of the proposed ordinance titled Ordinance of the City of Oxnard, California, amending sections 23-7, 23-4, and 27-10, and adding sections 23-13 to the Oxnard City Code, and review and recommend that the City Council approve the proposed resolution establishing administrative regulations to implement the provisions of the just cause evictions and the tenant protections ordinance and rent stabilization ordinance. And Ms. Brenda Lopez is the contact person. Yes, go ahead.
If I may, I think this is one where we are much further apart. What staff was proposing tonight on the amendments and regulation was to deal with some real-life issues that we are having today with what we would term some loopholes within our ordinance that are making it difficult to process these. This is based on data that we've been collecting since 2022 when we first had an ordinance. They were not to be a wholesale dive deep into our existing ordinance and fix every little piece. Many of the items that are being raised within the letters that we received thus far are very much the items that were debated heavily through 2021 and 2022. Respecting that we have a new council, that's probably a good debate to have, but staff's stance on it is we would really like to see if we could take this in a two-prong approach. And I know that Barbara Mac-Ortiz has that experience with us where we promised to bring something back, and sometimes that timeline, I can't see her through there, but sometimes that timeline does not meet her expectation, nor does it meet staff's expectation. So I know there may be a little fear on their side that we won't honor that. But I could have Alba speak to a few cases and a few of these tweaks that we really think are instrumental in helping both the tenants and the city and the landlords just process some existing cases that are here and here before us. So if possible, we think that there's a couple items in both the letter from Cause and from Barbara Mac-Ortiz that we say, yes, absolutely, that's right, that's a good catch, we should make those tweaks, and I can go through that. But when you get into the regulations concerning the fair right of return process, we could be here for days, and we would be here for days and hours and weeks, and we will probably be back in this council chambers multiple times to hash out those issues, because that is what happened in 2021 and 2022. It was at least 4 council meetings that we went through with committee, great dialogue that got us back to, or got us to this first ordinance that we have before you, or that we had before the council in 2022, that has been protecting our tenants over this time. But there are a few things that are pretty instrumental to us being able to be successful with cases that we have right now, to keep the city out of litigation, to protect the tenants, and to keep the owners from butting their heads against a wall where it's not clear. So we agree that the ordinances and regulations before you are not perfect. We agree that we need to go back to the community and work through some of those issues again. But I'd like to turn it over to Alba for a couple experiences that we're trying to work through right now. And then I would like to be able to hit on a few of the items that we agree with within Barbara's letter. There's 7 actually points within Barbara's letter that we agree with. And there's 1 within Causes that we agree with. Our recommendation is that we walk through those, we get some consensus from the committee on just those, and we agree to come back on a timeline for the fair rate of return exhibit that is most problematic for the group. Thank you.
Okay.
Excuse me, Mayor.
So
We did get a letter from Carl Lawson also.
His is also similar. The comments, and thank you for saying that, we went through the ones that we got before 1 o'clock. We got that one a little later. We have read that. He raises many issues that are also raised in both Barbara and Causes, and good points that Alba could speak to as we go through this process if we continue that. Thank you.
So a few of the things that we brought forth in the ordinance amendments, the first one was in regards to section 27-3. It's for at-fault just cause. What it discusses, it's replacing roommates. So there's been a trend in our community. There's quite a few families that are, the rents are higher. And due to that rent burden, people share a lot of their living. And typically what happens is if one tenant vacates the premises, it puts the remaining tenants in jeopardy of having their tenancy terminated. And so the language that we're proposing in this one is that the amendment, it does afford the owners the opportunity to object and also ensure that if there's a replacement tenant, that it's an authorized one, but it's allowing the replacement of a tenant on a one-for-one basis. So it's not a reason to be able to terminate someone's tenancy. And I can have Stephen Lewis to elaborate a little bit more on this specific provision and why it was brought forth.
Before we get into the specifics on it,
I'll just keep going down the list.
Just go through the big reasons of why we're looking to make at least some of the minor tweaks today, and then I think if we're gonna do it in the same format, if that's the way the committee would like to do that, we can maybe address each point, but kind of the big picture of why these specific changes.
For this one or for all of the sections?
All of the sections.
All of them, okay. So, and then the next section we proposed was section 27-4, owner intends to reoccupy the property. The language that we're changing here is, as of right now, an owner, if they're gonna terminate a tenancy and they're gonna do an owner move-in, they need to provide to the city a written affidavit within 10 days. But there's also part of our ordinance that requires the owner provide a copy of a termination notice within 5 days. So there's a little bit of confusion and discrepancy there. And so staff is recommending it be 5 days. So that way they mirror one another. So it's 5 days to provide a termination notice and 5 days to provide that written affidavit. So it makes it easier for property owners. They don't have two different dates that they have to worry about. And then it also assists, when there's public records request, or if a tenant needs to utilize that as a tenant's defense, all the documentation would have been received by the city prior to then.
Question.
You have a question?
Yes. When you're talking days, you're talking calendar days, business days?
It's calendar days.
Calendar days.
Mhm. And then the next one is section 27-13. It is a fee established. And so what it discusses, and it's something that's been brought up, is per the city's ordinance when it was adopted, Ordinance 3012 in 2022 recommended that a fee be adopted in order to pay for the program. The fees would be for rent stabilization and for just cause, both having their own fees. But this specific proposed amendment, what it does is in our just cause ordinance, let me see where it says here. Sorry, I'm looking at my notes. Okay, so what it would do is it would pull out information in our just cause ordinance and it would mirror our rent stabilization ordinance. So we have the language to be able to adopt fees for both. However, in our just cause ordinance, it's within additional tenant protections versus the rent stabilization ordinance. It has an actual separate section that talks about a fee that's going to be established. So it'll be easier for the owners to be able to find as well as tenants, and they'll mirror one another, the Ordinance 3012 and Ordinance 3013. And then the next one that we're going to be proposing is administrative regulations. So our Oxnard.
Alba, can I have you stop just for one second, just to try to split the two? Because so on the ordinance itself, Cause didn't raise any concerns with the actual ordinance amendments. Their letter is specific to the regulations. Barbara's letter actually does raise concerns with the ordinance. So items 1, 2, 3, and 4 are all related to the ordinance, although 4 is not asking for a specific change. And we actually agree, they're drafting errors. We agree with the recommended changes for the ordinance of Part 1 to add in on the bottom of page 1 of Macro Ortiz's letter. There you can see an underlined and bolded part that should have read additional replacement tenants. That's a change that we agree with. On item 2 in her letter, to make it consistent with a subdivision earlier, she recommends adding in, again, the part middle of the page, underlined in bold, domestic partner, children, grandchildren, parents, or grandparents. And also in the same paragraph, we flipped some words around, so it would actually say within 90 days of the termination of the tenancy. Those are errors that we agree that adding the clarification and making it mirror and then correcting the language. And part 3, number 3 on her page, middle of the page, the word relations needs to be changed to relates. We agree with that. We didn't see a change asked for in 27-13 fee established, as Alba just described. We're just mirroring the language within the other ordinance. So separating the two subjects from our regulations and the ordinance, I believe, at least from Just Cause and Barbara McElroy-Ortiz, were in agreement with the proposed changes. That's absent hearing the other public testimony we may receive tonight on the ordinance from the property managers and owners and landlord associations. As it goes into the regulations, that's where there is a lot of debate, specifically related to the fair rate of return exhibit. So hopefully that's a little bit clear that we have ordinance amendments before you and regulations. Ordinances, I feel like we're pretty close. Those ordinance amendments are necessary for Alba to do the job that she's been doing for the 2 years. The regulations are how she does the job, and that's where the debate is on. There are different ways to do that job, but this is the process that we are working through right now. And at this point, we're trying to just get it on paper so there's clarity. And again, we can come back and change these, and we agree that we will need to change them.
Can I proceed?
Would you, I guess that's a question for the committee as well. Would you like her to proceed to go through the regulations, or would you like to address the ordinance amendments and then move on to the regulations as a group? Okay, so if we can stick with public comments related to the ordinance agreement, since we're giving people multiple times to speak, that might be an easy way to do it. Then we can bring Alba and Stephen and others can speak to the regulation changes.
Madam Clerk, we'll go to the public speakers. We have Mr. Morris.
Good evening again. Again, I'm here on behalf of myself as a resident here of Oxnard, as well as a home provider, as well as the first vice president of the Ventura Coastal Association of Realtors. First, I want to affirm our commitment to keeping our members fully informed and complete with all legal requirements. Part of our mission is to provide regular legal updates and professional guidance that reflects our unwavering adherence to the ethical business practices. Our Realtor Code of Ethics is something that means a lot to us, and our both individuals as well as our members are expected to provide by that. In regards to the policy allowing tenant substitution of roommates when someone moves out, we generally support the process of making it easy for tenants to find a replacement. Collaboration and goodwill, along with a lot of help sustain a stable tenancy. However, we ask that this rule be clarified that at least one of the tenants from the original lease remains on the premise as a primary resident. And the reason for this is without that safeguard, there's a risk of endless substitutions after the next that can effectively lock the rent, even though no original tenant still lives in the property. Next, regarding the tenant protection ordinance fee established, we see a substantial cause for concern for all property owners of Oxnard. Throughout this process, we have attempted to provide good faith assistance, including our offer to help gather a robust database to evaluate the local housing market, something that we do constantly. Unfortunately, staff has opted to rely on just a 1-month snapshot of Craigslist listings, many of which are out of date, duplicates, and in some cases fraudulent, as well as data from the American Community Survey, which was already several years old and not really a reflection on the fast changings and changes that we have here in the city of Oxnard. If owners cannot trust these numbers, they will feel disenfranchised by this policy. We urge the council to slow down, involve all stakeholders. I appreciate we talked about getting together and trying to hash things out in a more thorough process, and commission a more detailed and accurate fee study before adopting that final policy. Finally, I want to close with our firm commitment as an association to being a constructive part of the solution. We believe deeply, I mean real deeply, that collaboration between the city, the housing providers, and the community stakeholders is a path forward together. And together, we can craft a tenant protection policy that truly addresses the city's concern without creating any greater problems down the line. Thank you again for allowing me to speak.
Thank you, Mr. Morris.
Just as one point of clarification, a fee is not proposed this evening. We've done outreach, and so some of the comments that you heard this evening are based on the outreach of the fee. That will come back at a later date. We've heard those concerns about the data points and how that's come about. What is being proposed again tonight is the ability to charge a fee. So that insertion of language into the ordinance in section 27, is it 10 or 13? 13. Is just the ability to do that exists in the rent stabilization ordinance, and we didn't have it in the tenant protections ordinance. So we're just mirroring that language. It's not a fee adoption before you this evening. There's still more work to be done on that. That'll come back before you in the next couple months.
Thank you. Maria Navarro, if you want to talk on this item, and then Barbara Ortiz.
I guess on this item, I second Barbara's comments in the letter. I still haven't had the chance to read Carl's letter. On the substitution of roommates and asking for clarity that at least one of the tenants remains on the lease, that seems like, very logical. So, agreed.
Okay, thank you. Barbara, do you have anything to add beyond the letter or anything? Okay. And then Julio Gomez.
Thank you again. This is Julio Gomez, a broker owner of property management. And the reason I'm here I want to establish something regarding to substitution of tenants. We owe a fiduciary to our landlords, and we have to be sure that somebody stays in the house is able to pay the rent. I have a specific case. There were two brothers. They're young, and one decided to get married, so he has to leave, make your own life. But he was putting half of the rent. So they brought people to try to qualify. So we went through all the channels to try to qualify. They didn't qualify because my fiduciary was to the landlords. So they give it 3-4 times to bring people to qualify, but say they had to be responsible to pay the rent. Finally, they found a friend went through the channels to qualification, credit, and all of that, and we put in the contract. So it's very important to have people responsible to pay the rent. We want to alleviate the problem. If somebody wants to move out of the property, it's okay, but they need to bring a substitute person able to pay the rent. That's it. That's the only thing we want. We want to alleviate the problems. Things happen in life, people move on, people change their status, and it's just here to help, to provide that. That's it.
Thank you, Mr. Gomez.
Mayor, we'll move on to the virtual speaker. Janet, if you can press *6, and you can speak right now. Thank you. Janet, you can press *6 to start speaking.
Sorry, that wasn't working. I don't know why. First of all, thank you. I don't know the woman who just spoke from Cause that said that they understand that for the original tenant. I appreciate that. I too have seen that where it really backfired down in Studio City, where there was an original tenant moves out, there were tenant stays, two original tenants. One tenant moves out, they move a roommate in. Then the following year, the next original tenant moves out, and then another tenant moves in. So it actually changed up the whole lease, and it ended up being a really crazy little case down there. So I appreciate that if we could put in the language, one original tenant must be on the lease and living in the residence. The other thing I would like to ask for is 5 business days versus 5 days. Because sometimes when we have a holiday, those days are not, there's no one at the city of Oxnard, or if there's, the every other Friday, someone might not be there to accept that notice and affidavit. I believe that both of them can be done at the same time. They're very simple forms. But 5 business days, because sometimes we like to actually see them being put into hands and getting a receipt for that. So if there's any way we could change that to 5 business days. And then I think my last, though we're not talking about the fee study, there were concerns about that not everyone had a stake in the game on that one. But it sounds like you're going to come back to us on that one, which I appreciate as well. Thank you.
Thank you for your comments. Thank you for calling in.
And Chair MacArthur, let's see if Matt would like to speak on this item. Matt, if you'd like to speak, press *6 and you can start now.
Yeah, no comments. I think everything's been covered. Thank you for asking.
Thank you. Chair MacArthur, that actually concludes our virtual speakers.
Thank you. We just proceed, Ms. Golden.
So now we're going to move on to the hard part, I think. The regulations are where there seems to be, where we're furthest apart here. Again, the regulations that were drafted were capturing how we've been processing these cases over the last couple years. Some of the items that are being raised are very much related to things that were debated earlier prior to the adoption of the ordinance. So let me figure out the best way. I lost some of my notes in the shuffle here. Give me one moment. Okay. So items 1, 2, 3 of Barbara's were related to the ordinance. So moving on to the overall regulations, I feel like we're going to dig deep into the fair rate of return petition regulations. Alba, would it be easy enough to highlight the concerns? I don't know if it's giving an overview of why give an overview, I guess, of why the regulations are necessary. And then from there, I think we may have to dive into each one separately, but big overview of hitting all of them.
Okay, so per our ordinance, what it allows, that it authorizes the city manager to adopt regulations for these ordinances in order to better administer them to our community. And so in the past 2 going on 3 years, we've seen that there are several loopholes that are open. And so in an effort to kind of address those situations and matters that staff has seen, we've proposed the following regulations. There are some comments, and so I think that's why I actually suggest we go individually over it. But one of the first regulations that's proposed is a registration regulation. So what we'll be doing is when we assess a fee for both ordinances underneath the program, as of right now, as it stands, both our ordinances do not require a property owner to register with the city. So we cannot charge a fee if we cannot have them register, and we don't know how many units are available in the community until, they register, and then we are able to let them know you have a fee associated with this, or they will exempt themselves. So the first one is regarding registration regulations. We are in the process of acquiring a program that other jurisdictions, rent stabilization jurisdictions, utilize throughout the state. And that's one of the first pieces. This registry is going to assist us too in the future, adjusting program fees, because we'll have a better understanding of what we see in our community. I don't know if you want me to talk about this, yes, okay. And so that would be the proposed regulation. It just would require all rental properties subject to both of these ordinances, either one or the other, to register. And then obviously, if not, they can just exempt themselves from the ordinance. The second is our right of first refusal regulations. And so what this does is it outlines the rights and responsibilities of owners and tenants when a tenant is displaced in regards to a substantial remodel. And so the proposed first refusal regulations clarify that if an affected tenant has the right to, under our sections, return to the rental unit from which the tenant was displaced, the property owner must offer to re-rent the rental unit to the affected tenant. Our regulations would require property owners to do the following: at the same rental rate that would have been applied if the tenants had never been displaced. And if there's been no rent increase, which has been proposed within the previous 12 months, then they could return at the same rental rate plus 4%. Additionally, the tenant would not have to complete or submit a new rental application. So that's a trend we've seen where there's a substantial remodel that's being done. Tenants are asked to vacate, but now they no longer qualify for that rental unit because they have to apply and there's a new process. They may have lived there 20 years. So it's something that's a trend that's been seen in our community. And additionally, too, it's without imposing any other type of requirement that the owner could not have imposed during the affected tenancy before the tenant was displaced. So if they're adding additional regulations or rules in regards to that in order for them to be able to come back to their unit, kind of as a way to deter them, because if they're underneath rent stabilization, they'd be capped at that rental rate of 4%. And so, let me see. And this does not hinder an owner's ability to apply for a rent increase as provided underneath our fair return petition, and it's consistent with state law. Our third one, it's our fair return petition. And so what we currently do, and that's the one that I believe has a few issues that Barbara and Cause have brought up, as well as some public comment, is the fair return petition allows for owners to apply to the city to petition for a fair return on their property if they're not receiving it. So say they state that the 4% is limiting them, they'd have to go through this process. And so what this regulation does is it outlines what that process would be. And what we're doing is we would be stating on court's opinion regarding Birkenfield versus City of Berkeley. It says here, so currently our ordinance provides this process in conformance with this, but we have no standard in which an owner's receipt or non-receipt of a fair return petition is determined. And so what it does is it's currently hampering the owner's ability to know what to actually include in the petition, and it's also hampering the tenant's ability to evaluate whether they want to oppose or support the petition. And so we have petitions currently in the process, and we have people wanting to apply, and so it's just something in order to clarify and clear up some of these ambiguities. Our next one is our Ellis Act regulation. So this is a gray area. The Ellis Act, it's a series of statutes via California State Code, but it prohibits local governments from stopping property owners from going out of business in regards to their property. However, it allows local governments to adopt regulations that prevent these owners from abusing the rights to withdraw their properties. And so we see oftentimes people that are saying they're going out of business or they're terminating via the Ellis Act when they're not, and they turn around and they re-rent the rental unit or they sell the property and they're not in compliance with Ellis Act provisions. And so our ordinance allows for it. We just need to adopt the regulations to enforce it. So we've seen a few cases in court as well where people were terminated via Ellis Act. They didn't comply with it, and the tenants unfortunately, paid the price with our court because we didn't have these regulations in place that the city is allowed to adopt. It says here, and I think that's all of them, a brief overview.
So I know she went through quite a bit there. The regulations, there's Exhibit A, B, C, and D. And within that, Barbara raised the majority of the concerns, both Cause and Barbara raising are in regards to Exhibit B. Again, we'll need to hear from the owner and property management side. There's also proposed changes in Barbara's letter related to A and D. And Generally speaking, we agree with the proposed change in A. And Regulation A is related to the registration that Alba first talked about there. And Barbara indicated that we needed to add an and/or. This is on page 3, midway down of her letter, and we agree with that change. Directly under that, she made reference to that. I think this is the small c is how we referred to it, but the reference to the civil code subdivision, we do need to correct that. She also put forth a couple other there that were, one other one about date of certificate of occupancy. That is not one that we'd be recommending at this time just because we did not research that enough to know what maybe the pitfalls were within that. But related to Exhibit A, we feel that the 2 of the 3 changes proposed, those are things that we should do. D, there was one small change related to an incomplete sentence where we needed to refer back to another part within within the regulation, and that is correct. That's an item we missed there, and we would recommend obviously fixing that within item D.
And that specific section would refer back to Regulation 1.03.
And then there was another issue that she raised in B, and it's a very minor issue compared to everything else, but we can hit that. But I think if we could get public comments related to exhibits A, B, and D, I'm sorry, A, C, and D, and hold off on B for a moment, we're going to get a lot closer to the sausage making or the chorizo that Council Member Perillo brought up earlier. But if we can get some public comments on, again, A, C, and D, I think we can get to consensus pretty quickly on those ones.
If we break it up that way, Madam Clerk, are there any public speakers on those exhibits?
No, yes. Janet, if you can press *6, start speaking now. Janet, if you can press *6 and you can start to address the committee now.
This is Matt. I think you unmuted me first.
Correct. Would you like to speak now, or we can come back to you?
I'm sorry, you called Matt, correct?
Matt, you can address the committee now if you'd like.
Okay, I'm sorry. Yeah. So I'm not speaking on B yet, correct?
Correct.
Okay. Can I just circle back at the end? Because I want to make sure I don't speak on B and my notes are all together.
Sure.
Yes.
Thank you.
Thank you.
No problem.
Mayor, if it's easier to get them all, I'm just saying that one you're going to get a lot of comments on, but if that's going to be difficult for everybody, we're open to another way to handle that.
Janet, if you can press *6 and you can speak now.
All right, here I am.
Thank you.
So we're taking D, right, as well? D, we are talking about D.
Yes.
Is that correct? Okay. So first of all, without seeing Mrs. Barbara Ortiz's notes about the and the or and stuff, and just adding them, I don't know how that's going to relate, because that's, I'm one who has to physically read it to make sure that that's something I can agree to. However, when it comes to the Ellis Act, I'm very confused about this because I was actually part of the original group when Emilio Ramirez had said, hey, I'm looking for people to chime in on this. So we did like 20 some hours on this. And he had always said the way that it was written is that if you pull your property off the market, which means you're definitely not going to be renting it, which means when in case there is a sale on a property, which is the Ellis Act, there's the sale on the property, the buyer would have to give the notice to the tenants because the seller does not know what the buyer would be doing. So we have been preaching that to all of our fellow realtors about what you can and cannot do. So if someone is pulling it, is what you're seeing now lawsuits against that, and they're not winning because that was really told to us over and over and over again. So is that not correct any longer?
Stephen, I mean, I know what we're putting forward is just saying what we do. Would you be able to address the question that Janet just raised?
Yes, it is not necessary or appropriate even if an owner is selling a property that's a rental property for somebody else to continue renting, that property should not be withdrawn from the rental market under the Ellis Act. As Janet mentioned, the purpose of the Ellis Act is to allow an owner to go out of business, not just to sell the property. If an owner withdraws the property from the rental market under the Ellis Act for the purpose of going out of business, and it's later put back on the rental market, there are certain rights that the Ellis Act gives to tenants. And in order for them to know that they have the opportunity to assert those rights, they have to be given notice that the property is being put back on the rental market, and the buyer, if it's the buyer who's now deciding, well, I bought this property that was withdrawn from the rental market, I want to put it back on the rental market, they do need to have all the tenants' contact information to provide them notices. So yes, that is still true. It's the person putting the property on the rental market who needs to contact all of the tenants that's happening. But again, that should only be happening in very rare cases, because the purpose of the Ellis Act is to allow an owner to take a property completely off the rental market for the purpose of going out of business.
Okay. So with that said, when we are looking at apartment communities, you cannot clear out an entire community, because that is against now SB 567, which Oxnard immediately adopted when that came out, that says, hey, there's treble damages per each lease. So I think there's already something on the books when it comes to D. I don't think it has to go any further, because now you might start getting this very convoluted, which is a very stringent law, SB 567, about taking things off the market. And the tenant does have the right to go after anyone who does give them notice, because Oxnard says there's 4 reasons and 4 reasons only, and taking off the market is not selling a unit. So I think that's already been hashed out, unless you're going to specifically put that in the ordinance, so that, if you need to do plainer language regarding a sale of a home when it comes to residents, that might be an option, because it's already been put out there. So that would be covering for D. The rental registration regulation, so this came out, so we're I guess like 4 years, 5 years down the road now, pretty much, with this ordinance. And we have always said to register. The idea is you have to get registered so that when a fee comes out, you are not fined because you did not register the unit. So are you asking now for a different type of registration, that you want every single property to re-register? I'm confused about that. So if you have the registration, whatever software you're going to use should automatically go into that registration, and a owner should not have to re-register, because I'm thinking about those large units, unless now you're going to require more information that was not already asked for. So if that's what you're requiring, what is that information that you're looking for? And then first right of refusal with substantial remodel, that's covered under SB 567 when it comes to if someone's doing that and they're getting out of it, but you're asking for, this is still the same first, I guess this was my question again. First right of refusal, is that going to be after the 6 months, or are you still sticking within what is now in the ordinance of up to 6 months?
I think one general clarifying question I'd like to say is there's no changes proposed to the ordinance related to those items. There's simply regulations that show how the ordinance is, the process that we go through and make it clear. So the items that Janet just raised in terms of a change on Ellis Actor registration, nothing's proposed before you this evening in the actual ordinance. The ordinance is the first part that we went through, where Alba went through the 4 items that we were changing. Now it's items that are already adopted in your ordinance and how we process them and how we review them to provide that clarity to both sides. We never created the registration, so to answer Janet's first question there, are we doing this again? We've always talked with both sides about the need to have a registration. We are just now acquiring and testing the software to have some of that. It looks like Alba, I'm wrong on that, so Alba's gonna correct me.
So we recommend people register their properties, and we do have a property registration form. And we do share with them that there's going to be a fee associated with that. So we have been receiving them from the public. However, it's not required in our ordinance. So even though we have a fee, so you are correct, we have a fee that potentially could come. It's just it's a may, we recommend you do it, but this would actually require them to actually do it. And then same thing, some of those updates would include just updating us if there's a change in ownership. Property management companies change often, so that changes within years. Our ordinance has been around since 2022. People change property management companies sometimes yearly, other people stay with them long-term. So it's kind of finessing some of those details and just giving that clarification. So.
Is there a change in the data that, I think one of Janet's questions was, is there a change in the types of information that this regulation is asking for versus the method that we use right now?
As far as I'm aware, no. It'd be the same information. Right now, we just ask for the property owner's information, contact number, and email. We also ask for the property manager, and then we ask for mailing addresses. And we do both, like I mentioned, because oftentimes property managers change or owners change. And so it's up to the owner or the property manager to let us know, hey, I'm managing this property now, or the owner to say, hey, this property was sold, I'm the new owner, I'm registering it. It's not a requirement, so not everyone does it. It's a recommendation so that once a fee is assessed, we can easily contact them and let them know the city has this fee. Please be made aware. We understand you have X amount of units, or we've been made aware your property is exempt from this fee, but we're letting you know that this is what was enacted, because there's other property owners who've exempted themselves and say this doesn't apply to me, which that's on our form as well. So it'd be the same information. It'd just be via a database. So it would make it easier for the community and for our landlords to be able to do it online versus right now it's paper forms and we accept them via email, mail, or walk-ins. I get a little bit of everything, so it would just kind of streamline that process.
Can I ask a further question? Are you looking for a request of how many days it should take to make that change? Sort of like the DMV, like if you move into the state, you got 10 days to change everything over? Is that what you're asking for when there's a change of ownership or change of management? Because
sorry, I'll let you finish.
Oh yeah, because the property is already registered. So it seems to me like the new owner, if they're going to be living there, would have to pull it off of the registry. So I think that there should be something that says, hey, if there's a change or you're no longer a rental property, you have a certain amount of timeline to get that done.
Yeah, so the regulation, what it's going to state, it says correction of inaccurate or incomplete information or correction of changed information. So it's within 10 days would need to be provided to the city. And so that includes, it's the same information on the previously submitted registration form, but this includes the change of the identity of the owner, because the property itself doesn't change. The parcel doesn't change. The property doesn't change. It's typically who's managing it and how we can contact them. So that's what we're needing information for. Oftentimes there's a mailing address, but there's a delay with that. So if there's emails, there's phone numbers, that assists staff in the future. And then as well, if there's any questions or concerns, we're easily able to speak with them.
Okay, I think your biggest problem with the registration when it comes to single-family homes is that no one understands the language that you've put on the registration form. Because when someone calls me and they say, well, what box do I choose? I said, pick the biggest paragraph. That's the single-family home. So I think you have to perhaps put single-family home and then spell everything out so that they understand a single-family home or a condo falls under this. Because they just don't understand. It's too many words. It's very legalese, and some of your mom and pops are just not there.
And we can elaborate that this language is taken from the state. So the state's ordinance, which is AB, well, it's not an ordinance, but the state's Assembly Bill AB 1482, which became a civil code, the language it talks about is separate and alienable by title. It's specific because you can have a single family home, but have 2 or 3 on one lot, and that will be a multi-unit. And so it's the same thing with condos. That's why it's separate and alienable. So I can't say all single family homes are exempt because not all single family homes would be exempt. It depends. It's on a case per case basis. The majority are. However, there are some exemptions.
I do have something to add. So hearing this feedback is great. And this is something that as we've been working to develop the online platform that we'll be taking in this registrations, we've thought that through. So we have that language that we have to have, but we have a lot of pop-ups and the little hover where you hover over the question mark to give you more information to make it easier for people to understand some of these the technical jargon and just really make it more user-friendly. So that is something that we're really incorporating into the online platform and being really thoughtful in order to make it simpler.
Thank you. That's all my questions. Thank you so much.
Yeah, thank you for your comments. We'll keep going.
So I think that concludes the on A, C, and D. I think to address the other concern that Janet had of not knowing where the change was, I was going to have Andrew actually read that section of the regulation, both for A and D.
Yeah, the section that was originally referred to by the caller inside of Barbara's, the section that was originally referred to by the caller, referred to in Barbara's letter, specifically states, that said, one issue that I noted under regulation 1.05 subsection E is a reference to the new date of withdrawal under paragraph, and then it references just blank. So that particular section under the Exhibit D, I'm going to pull up and read specifically for subsection E that's referred. The full portion states within 90 days of the date of delivery, the city of the notice of intent to withdraw, the owner shall give written notice to the public entity and the affected tenants of that extension of the date of withdrawal and the new date of the withdrawal under paragraph, and there's nothing there in the current regulation. It should refer to a previous regulation, specifically 1.03.
Council, that's on page 59 of your packet, or community, if you have the whole packet, that's page 59, again, under regulation 105.5E, we would simply be adding 1.03 to the very end within Exhibit D.
Thank you. Maria, did you have a comment on that? Yeah.
I actually did regarding registration regulations, and I wanted to just kind of play devil's advocate here and kind of go for something maybe a little bit more wilder, but I propose that this actually be taken as an opportunity to collect a lot more data. I think it's an opportunity for us to actually be able to see how much people are charging for rents. And like there's other rental registries that actually ask for property owners to report how much the tenants are being charged, and then year by year update that information. That way you could update not only the owners and change of management periodically, but you could also get data, right, to know whether this program is working. So just throwing it out there. And then the other thing I wanted to say about the right of first refusal, I know I've had conversations with Alba a little bit before about that carrying through to the next tenancy. So for example, if there's a substantial remodel, the tenant leaves, the next tenant then gets that rental rate that was there for the previous tenant, or can the landlord then increase rent to market rate?
Is this in regards to a property that would be covered under rent stabilization, so the owner terminated the tenancy? So yeah, that rental rate would stay. If so, just so everyone's aware, if an owner terminates for no fault, which means it's no fault of the tenant, any future tenancies, if it's not that tenant or it's a future tenant, they would be capped at 4%, or what the rental rate that the previous tenant was paying plus that 4%. And Stephen can elaborate a little bit more on the reasons why.
Yes, under state law, an owner has the right to establish a new rent for any new tenancy, except for a new tenancy that occurs after a previous tenancy was terminated for a no-fault reason. So if a tenancy is terminated in order for an owner to do a substantial remodel, and then the unit is re-rented to someone else, that person could only be charged the amount that would have been legal to charge to the person who was displaced. And that's consistent with state law.
Thank you.
Chair MacArthur, Matt would like to make some comments.
Okay.
Matt, if you can press *6 and you can start speaking now. Oops.
Thank you. I appreciate the opportunity. I want to look at this from the standpoint of markets change. And one of the things I see here is a 120-day notice for intent to withdraw the property. And I always think of one of my owners recently that was under financial stress and they needed to sell their multi-unit property. They're going to withdraw. They're going to sell. It has to be done. But people under financial duress, and when the markets change like we had in, 8 and 9, and back many years before that, these time frames present a problem. They could be problematic. Looking even further here, under Regulation 1.05, number 5, an owner or a tenant that's 62 years. By the way, I'm older than 62, so or disabled can stay a year. It just defies logic why anyone would stay in the rental business. Any small operator. I guess my point is that the harder we make it, the more we're going to lose the small mom and pop. And I can't emphasize that enough, because as many as we talk about the bad operators, and it seems to be like the real catchphrase here, there's so many good people that have long-term tenants, and I just don't want you to forget about that have played by the rules. They've done the right thing. And you almost need a master's degree to read some of these things and to get to the finite granular process, or to rehab or redo your properties. The harder we make it, I think the more likely a guy like me is to look at one of my owners and say, just get out of the business. This is crazy. And what happens is you replace them with the big guys, the big overseers, the people that we never see and never hear from, that come in and they take over properties. And what they do is they learn how to work around these things. And I think that just what I can do for this city as a volunteer and for the long-term gain, I think is kind of missed by having these regulations be so strict. And I want you to look at that and consider that. The other thing that I see here is the recording. Ventura County recorder have to record a notice. I just don't. Can somebody explain why that is? Not really. Let me pull up the section here. It's 1.04, no less than 120 days after the owner intends to withdraw the property. The owner must record a Ventura County recorder, a written notice. I'm not even sure what. Can somebody explain to me what the why we're not just notifying the city? Why would I have to go and record a notice? That just seems overly burdensome and unnecessary. I'm not really understanding what the purpose is.
We're gonna defer to Stephen Lewis and also to address some of these questions regarding Ellis Act, which is a state law. So we're deferring to Stephen Lewis.
Yes, as I mentioned in some of my comments previously, if tenants are displaced under the Ellis Act, they then have certain rights, including the right to return if the property is returned to the rental market. As a previous speaker had mentioned, sometimes this happens after the person who owned the property at the time of the displacement sells the property to someone new. The obligation to notify the displaced tenants of their right to return to the rental unit, if it's put back on the rental market, then falls to the new owner. In order for the new owner to know that they have that obligation, it has to be recorded against the property. That is stated in state law in the Ellis Act itself, that that must be recorded in order to be effective. That's the reason for that requirement. Also, with respect to all of the regulations that are included in this proposal, they are all pretty much word for word from the state Ellis Act. I can answer any specific questions if anyone has them.
Thank you.
Excellent. Thank you. Thank you again.
Thank you, Matt.
Thank you.
So I think the other change that we maybe needed to read in to make it clear was Exhibit A, Regulation 1.013, the and/or. That was recommended by Barbara. That's on page 42 of your packet. Exhibit A, and also the same page, there was a change to Regulation 1.02, 2A, and Andrew, do you have those two, or do you need me to read that? 1.01 and 1.02 of Exhibit A, regulations on registration.
So here the change should be specifically for and or needs to be entered under Regulation 1.01. This regulation requires that all renter properties subject to Section 27-29 it should state and or Section 27-13 be registered with the city.
And then on that same page, section Regulation 1.02, there was a reference to a civil code where we used a capital C.
And it's specifically Civil Code Section 1940. And here it's subdivision C. It references a capital C, but it should be a lowercase c for that provision.
So I believe we've read 3 changes into the exhibits that we would recommend. That would take care, based on the comments that we heard this evening, for changes to Exhibit A. There were no changes proposed to Exhibit C, which deals with right of first refusal, and then with an Exhibit D, as we just heard from Mr. Lewis, this is pretty much directly from state law, but we did have a error on page 59 of your packet, which is Regulation 1.05 of Exhibit D, subsection E, where we simply need to add at the very end of E 1.03. That leaves the meaty part of the topic this evening, which would be Exhibit B, which is the petition by the owner for the rent increase to achieve a fair return. This starts on page 44 of your packet. The majority of Barbara's letter dealt with this exhibit, as well as Cause had, I believe, 2 or 3 points on this. But before we dive into the back and forth, and again, this is back and forth that we did have quite a few years ago. Again, Albert, this is one where I think if you can get up and explain the need for this currently, and again, I will continue to use the phrase of don't let the perfection be the enemy of progress. We have existing cases that this would benefit. It is not perfect. There's much room to debate this again if this is the right process. Much of that debate is about the hearing officer, the appeal, the timelines. That was a choice that the previous council made. That is the ordinance that the current violations or potential violations are under right now. So with that, I'd like Alba to get up, and Stephen, I'm also going to look to you just to kind of have some general comments about why we're not recommending these changes to Exhibit B at this time, just to prepare you for that. So Alba, if you can start.
I'm just going to gather my documents and then I'll be able to address all of the questions. And I'm also going to defer to some things for Stephen, so give me a quick second.
And Alba, you don't need to go point by point through Barbara's letter right now, just kind of the general need for this, because I think the people will still speak, but just kind of want to set that context before we hear all the public comments on this.
Yeah, so what our fair return petitions are is it allows for an owner to apply for a fair return on their property. And so obviously if they're not receiving what they deem a fair return, they're availed the ability to go through this process, the property owners. As of right now, the way our ordinance stands, there's not as much regulations in place. So there's not as many definitions. The property owners have a little bit of, it's confusion of what they should provide and what they shouldn't provide. We do have a fair hearing officer that we contract with that has reviewed, a fair hearing petition. But this would allow for clarity between landlords and tenants. And so this is oftentimes in situations where, say, the property has either been below market for several years or someone buys the property and it's severely below market. And so this is their ability to address that. And then I will defer to Stephen to kind of elaborate a little bit more on this.
Let me just first begin very briefly with explaining why this provision in the ordinance exists in the first place. That is providing for an opportunity for an owner to apply for a fair return. There is a constitutional requirement that government not impose regulations that are so onerous that they prevent somebody from achieving a fair return on their investment, which basically means the ability consistent with normal investment practices to earn some kind of profit. There's no constitutional guarantee to a profit, of course. If you invest in something, you may lose money. But there is a constitutional requirement that the government, not by regulation, prohibit the ability to earn some sort of profit. And so for this reason, every rent stabilization ordinance that exists has to provide some opportunity for an owner to make sure that if, as a result of the regulation, their income potential is so reduced that it's impossible for them to earn any kind of profit, there has to be a mechanism for their income to be adjusted. That is, for them to be able to increase the rents, in this case, to be able to achieve a fair return. So the ordinance provides for that mechanism to occur, but it doesn't state what is a fair return. Very early on, very shortly, I think within a matter of 2 or 3 months after the ordinance being adopted, an owner said, I'm not achieving a fair return, and so I want to increase my rent. What they said was, we looked around the country, and throughout the country, owners are making about 10% a year. We're not making 10% a year, so we believe that we should get a 10% rent increase because that's a fair return. There's nothing in the ordinance to say whether that makes any sense or not, Although, because the ordinance says you're limited to 4%, that clearly is a problem unless the owner can show why why that is just somehow facially unreasonable, which they could not do in that case. In order to prevent this sort of inability to move forward in the future, and also in order to make sure that everybody is treated the same, that is, that the same standard for what constitutes a fair return is applied to every owner, staff concluded that it's important to come up with a definition of what constitutes a fair return. And in doing so, we looked at ordinances, rent stabilization ordinances throughout the state, and borrowed the most common measure of fair return, which is that there is some consistency between the owner's net operating income in a year before an ordinance was adopted and the current year, in order to make sure that the fair return that they were getting on an unregulated market is more or less locked in when the market becomes regulated. The base year under the ordinance is the year before the ordinance went into effect, because the owner was presumptively achieving a fair return because they were able to charge whatever the market would bear. And so if they were not, if they were making some specified amount of money, they were making that money presumably because that was a fair return for them. So that's the reason for the base year being the year that the ordinance was enacted. What the ordinance then does is say, we will look at the rate of inflation from that year to the current year, see what the change in CPI has been over that period. And if the owner's net operating income has not been consistent with the rate of inflation over that time, they're entitled to some sort of adjustment to bring them up to that level. That doesn't mean that rents are adjusted by the rate of inflation. Rather, their net operating income has to keep up with changes in the rate of inflation. Net operating income is their gross income minus their operating expenses. This ordinance is a somewhat, this set of regulations is a somewhat bare bones set of regulations to impose that formula so that everybody can look at it, see what it is, and an owner can say, okay, I need to state what my net operating income was in the base year, say what my net operating income is in the current year, show what the change in the rate of inflation was over that period, and then allow the hearing officer to make that calculation. It's not simply a matter of calculation, it's also a matter of looking at all the claimed expenses and revenue to make sure that there is evidence to support them. That's why there has to be a decision maker rather than just there being just some formula that's automatic. There are a number of concerns that have been raised with respect to the regulation as proposed, many of them related to how quickly it occurs and the fact that it occurs only based upon a written record. The reason it was drafted that way is because the ordinance as drafted provides for a very short time period, 60 days, from the time that the application is filed and that the decision is made. It's difficult to have a process that's completed in such a short period of time if there is an in-person hearing. Because a regulation can do no more than operate within the ordinance under which it's authorized, that's what's been proposed. It may be appropriate to lengthen that period of time in order to allow a more robust procedure, but as of now, the time period that exists in the current regulation seem to suggest a more truncated procedure. Given that there's no right of appeal, it does seem sensible for there to be a longer procedure with in-person hearings, but that's not what the ordinance currently provides for. Thank you.
I think with that general explanation, if you would like to call public speakers back up, One other option that I'm just going to put out there, because it looks like some are maybe tiring. This is a really important regulation for us related to the existing cases. This was actually part of the reason we put these ordinance amendments and regulations before you. However, we do have consensus, I believe, on the ordinance amendments themselves, which was item 1 of your agenda, the first recommendation. And we do, I believe, have consensus with some minor tweaks that we've already gone over for exhibits A, C, and D. One option is to send those to council with a recommendation of committee, if that is your pleasure, and have us continue to work on exhibit B with both sides. That does not get staff to exactly where they want, because again, and as Mr. Lewis just described, this is what's currently in our ordinances, and this is the regulation to implement that ordinance. That again is kind of rehashing everything that we debated back in 2022, which is still proper. It just doesn't help us address the current cases that we have. But that is an option I wanted to put out there that just came to me as we were going through this and seeing some of the progress that we made. So depending on which route you go there, clearly we have speakers that have some input on Exhibit B.
Sure. Well, one thing is we're making a lot of progress, that's for sure. Councilmember Pearl, do you have something?
Question. Assistant City Manager Golden, on Carl Lawson's letter, his second to last paragraph, is that it seems like increasing timeline. Is that what the gentleman was just speaking of at the end of his comments here? Is that similar, or that's totally out of left field? Or Mr. Lawson? Roselle?
Within his letter, Councilman Perla, which, I mean, he does talk about various timelines that are all within this Exhibit B. What Mr. Lewis was just talking about was the overall 60-day timeline. Carl's letter speaks to the 7 days, the 14 days. There's many. So just so that I answer your question properly, are you looking at a certain section of Carl's when you say the timeline?
He said that he had a couple of concerns, but at the very end, his paragraph, from a particular point, I'm reading second to last paragraph, from a particular point of view, I conclude that these 7-day and 14-day timelines are, as proposed, are simply unworkable. I thus recommend increasing timelines to increase the likelihood that quality work products can be produced in a way that serves all parties involved, including the city, in a quasi-judicial process such as this. Due process guarantees demand nothing less. If he's not talking about the same, correct me, but if he is, I know that Mr. Lawson, I don't believe he has an axe to grind. I trust that he worked for the city and did a good job, and I think that he bears and brings something, puts it on the table. And I'm
So those two timelines that are referred to are part of the 60-day. And what I would need to do here is a combination, I believe, again, of Alba and Stephen, of how those play into it and the unworkableness of it and what you've been up against thus far. Stephen, I don't know, I think you probably understand the council members' questions from that, because I don't know also that you've seen Carl's letter, but he is talking about, I'll go back and find the specifics for you if you need that, when he refers to the 7-day and 14-day timelines not being workable within this regulation. Alba, do you have? Okay.
If those timelines are extended, then it probably makes sense to extend the entire 60-day period, because the further it goes before everything is put before the ultimate decision maker, and given that these cases can be very document intensive, it probably makes sense to extend the entire timeline, including the 60-day period, in order to accommodate longer timelines at the front end.
Committee members, Elle McCarron, City Attorney's Office. We do agree with Mr. Lewis and with what the original letter proposed. One simple fix would be to add in some extension period language to these timelines in here, whether it's 7 days plus an additional 7 days if needed, and we would notice it up, and then you could do a 60-day, or I'm sorry, for the 60-day limit, you could add an additional 30-day extension or 2 of them upon appropriate notice. so that staff has ample time to review these petitions. So we are limited here by these, I guess by the timelines and the number of days, and it doesn't afford any relief if we're not able to make those deadlines. So that's a pretty easy fix.
Does staff see a problem with that?
No, we concur.
Okay.
Thank you.
Thank you.
Chair MacArthur, if we can allow Janet to provide a few comments. Janet, if you can press *6, and you can start now.
Can you hear me?
Yes.
Perfect. So I have to let you know that as a realtor, right now at this point, because it's so late at night, we support development of a petition for fair return and believe stakeholders and staff need additional time to develop a properly functioning ordinance. Because I don't know if everyone's brain is quite working in full speed. So I just worried about that. Because it's so important. Thank you.
Yeah, there's so much here to go through. I don't know what your wish is, Perella or Councilwoman Perez, if it's possible that we can just either table this or maybe agree to what we made a lot of progress. I don't know if we're ready to bring it to full council even on A, C, and D, or if we'd like to bring it back to committee after just further discussion with the party. I agree with the caller. I think a lot of us are getting tired up here. Yeah. Yeah,
So
I would, Councilwoman Perez.
So just so I'm clear, the option would be for the items that we've agreed on, move those forward, and for Exhibit B, circle back on additional needs for that. Is that correct?
So it would be moving recommendation 1, and in regards to recommendation 2, that you would move items A, C, and D to the council and come back to committee with regulation B, which clearly needs more work.
Yeah.
As an alternative, you can table the entire, items that we've gone through already. That just, again, we have cases that affects.
Right. And just in addition, I would like to inquire about, and not to deviate too much from the conversation, for Regulation 1 under registration, is there an option to include data regarding cost of living as recommended by one of the speakers?
I think you're speaking to what Maria raised of collecting more data. I mean, we now have the Realtor Association groups that, one's still here, to know if there would be opposition to that. Again, that's something easy to bring back. That's not an ordinance amendment, it's a regulation, and we actually have the ability to change these to a point administratively. But Alba, is there a reason that we didn't put that forward to begin with?
No, but it's something that we can include, and then I can defer to Stephen about how other jurisdictions do it as well and how they collect that data.
Many other jurisdictions do have rent registries, not just property registrations, but rent registries. The City of Oxnard ordinance does not include a rent registry, only requirement that that a fee be paid. The purpose of this regulation is to further and make possible, in fact, the collection of that fee. In my view, if the city wants to require owners to provide rents as a part of the registration process, and to determine that a registration is not complete unless it includes that, it should do so by ordinance, because a regulation can only do those things that are necessary to fill in the gaps with respect to an existing ordinance. And again, the existing ordinance, there's no registration of rents requirement. The purpose of this regulation is only to facilitate the imposition of the fee that the ordinance requires. So in case there was any clarity what I said, I don't think that it would be advisable to, you can certainly ask for that information, but I don't think it would be advisable in the regulation to require it unless there's an ordinance amendment to specifically require it.
Yeah.
Chair MacArthur,
I'm sorry, go ahead. Madam
Janet
Clerk.
would like to make a couple of comments.
Sure, absolutely.
So Janet, if you can press *6, or you can start speaking now.
I would think that this is something that we would also want to table as well, because this has been, in looking at the rental registries and pricing, if it's a matter of just throwing a rent roll up, that's one thing, but if you know, I would say it's very onerous to have that conversation now, because there would be a lot of conversation that would need to happen around that. That's my philosophy on that one, because we didn't come to talk about that. You know, we didn't know that would be something that would be added at the last second. So I think we would want to dive deeper into that one amongst the community.
Thank you, Janet. Yep. Well, I'm prepared to make a motion if, maybe to approve the recommendations and the changes, but then direct staff to come back with Exhibit B to this committee after further consult and with the various stakeholders. That's my recommendation. That's my motion.
I'll second the motion.
Yes, sir.
Correct.
Okay, all right, thank you.
Thank you. Madam Clerk, can we call for the vote?
Do we need to re-clarify the motion or something, or?
No. Committee Member Pettis?
Yes.
Committee Member Perallo?
Yes.
Chair MacArthur?
Yes.
And the motion carries 3-0. Thank you.
Thank you. Thank you, Mr. Mayor, for clarifying that with the city attorney and the city manager. Thank you. Thank you, Mr. Lewis. Thank you.
Thank you.
And thank you, Maria and Barbara and the callers, Janet, for calling in and sharing your insight and comments with us. Thank you, everybody. Thank you.
Thank you. Appreciate the time.
Yeah. Well, thank you. Unless a member has an item for a future agenda, and there be no further business on the agenda, and without objection, we are adjourned.
Yes,
Thank you.
I
Well,
do
you do.
have-
I'm sorry.
I
Go
do.
ahead, Mr. Perlow. It's getting excited here.
I would hope that we can get something on our agendas that we put out, in either the weekly packet or on various sites, so that there is a link in big letters, colored letters, whatever distinguishes a difference, so people can go to that site and pull up the entire staff report, so they can pull up all the pages versus just the highlights and measure them. I think that we need to do that, not just for this body, but for every other body. But I'm making it for this body. I'm requesting that come forward. However it comes to here, or it goes to the governance, but I will not stop requesting that. I get too many people asking me, well, they saw it, it's only 2 pages, and you tell them there's 19 pages. And they ask me, where the hell are they?
Committee Member Perallo, that is something that we can actually do without having to bring it back to committee. That's a simple fix. Okay. We put it out every week, so that's a quick, easy fix. Okay, thank you.
Thank you, Madam Clerk. Okay, if there's nothing further without objection, we are adjourned. Thank you.